standing, but you may be seated. Sorry, just as a formality, the gallery, please, the noise emanating from the gallery comes straight towards the court, so please try to limit conversation or as softly as possible, please. Informing me that the camera from this side is causing a disruption. She can hear it on the headset that she's wearing, and therefore it will disturb the record. Have you taken it out? And you can just check with her. Thank you very much. As a formality, the court had established from the state and the defense that there was no objection to the media being present. I don't have a list of who is present to acknowledge their presence. During the proceedings, you may note your names and where you are from, and I will place it on the record when the list is completed. Having said that, indeed the court is ready to proceed with judgment in this matter. You'll have to bear with me. The court is a court of record. Therefore, even the formalities, all evidence presented must be placed on record. So I cannot push the fast forward button and reach the end without placing everything on record. Okay. Therefore, accused 1 then, Mr. Julius Malema, accused 2, Mr. Adriaan Snyman, hereinafter referred to as accused 1 and 2. For the state appears Advocate Sisa, and on behalf of accused 1 appears Advocate Alhodes, as instructed by Ian Levitt attorneys. and the position remain unchanged during the proceedings to date. On behalf of accused 2 appears Advocate S. Matthews as instructed by College, Crowcard and Associates Incorporated. The position has remained unchanged for the duration of these proceedings. In respect of count 1, it is with regards to accused 1 only. The statutory count 1 reads as the statutory unlawful possession of a firearm in contravention of section 3, read with sections 1, 103, 117 and 120 in brackets A, 1A, and read with section 121 of Schedule 4, section 151 of the Firearms Control Act 60 of 2000, and further read with the sections 156 and 250 of the Criminal Procedure Act 51 of 1977. Count 2 is also in respect of accused 1 only. Possession of ammunition in contravention in 20 sub 1 sub 8 and 121 read with Schedule 4 and section 151 of the Firearms Control Act 60 of 2000. In that upon or about the 28th of July 2018 and at Sisa Dukashe Stadium in Mdantsane. Sorry, let me just start. I need to read the contents of count 1. My apologies. Count 1 refers to the following. In that upon or about the 28th of July 2018 and at Sisa Dukashe Stadium in Mdantsane in the Regional Division of the Eastern Cape, the accused unlawfully had in his possession the following firearm: to wit a .223 Muko rifle, firearm, the make of the firearm unknown to the state without holding a license or permit or authorization issued in terms of the Act to possess the said firearm. Count 2, the charge has been read out on record. I will now continue with what is alleged. In that upon or about the 28th of July 2018 and at Sisa Dukashe Stadium in Mdantsane, in the Regional Division of the Eastern Cape, the accused did unlawfully have in his possession the following ammunition: to wit 1 times .223 Remington bullet, without being the holder thereof, without being the holder of the license in respect of a firearm, capable of discharging that ammunition, or a permit to possess ammunition, a dealer's license, manufacturer's license, gunsmith license, import, export, or in transit permit in terms of this Act. Count 3, also in respect of accused 1 only, that the accused is guilty of the offence of contravening the provisions of section 120, subsection 7, read with sections 1, 103, 120, in brackets 1, bracket A, section 121, read with schedule 4, and section 151 of the Firearms Control Act 60 of 2000, and further read with section 156 of the Criminal Procedure Act 51 of 1977, being the discharge of a firearm in a built-up area or any public space. In that upon or about 28th of July at Sisa Dukashe Stadium in Mdantsane in the Regional Division of the Eastern Cape, the accused did unlawfully discharge a firearm to wit a .223 Muko rifle and or a firearm, the make of the firearm unknown to the state, in a built-up area or any public place, to wit the Sisa Dukashe Stadium in Mdantsane without good reason to do so. Count 4, is in respect of accused 1 and 2, in that the accused persons are guilty of the offence of contravening the provisions of section 120, subsection 3, read with sections 1, 103, 120, 1A, and section 121, read with schedule 4, and section 151 of the Firearms Control Act 60 of 2000, and further read with section 156 of the Criminal Procedure Act 51 of 1977, meaning failure to take reasonable precautions to avoid danger to person or property. In that upon or about the 28th of July at or near Sisa Dukashe Stadium in Mdantsane, within the regional division of the Eastern Cape, the accused had control of a loaded firearm, to wit a .223 Narinko rifle, and or a firearm the make of the firearm unknown to the state, in circumstances where it created a risk to the safety or property of the general public attending the 5th Economic Freedom Fighters celebration, and unlawfully failed to take reasonable precautions to avoid the danger. Count 5, in respect of accused 1 only, that the accused is guilty of the offence of contravening section 120, subsection 3B, read with sections 1, 103, 120, 1A, and section 121, with read with schedule 4, and section 151 of the Firearms Control Act 60 of 2000, and further read with the provisions of section 156 of the Criminal Procedure Act 51 of 1977, being reckless endangerment to person or property, in that upon or about the 28th of July 2018 and at or near Sisa Dukashe Stadium in Mdantsane, the regional division of the Eastern Cape, the accused had unlawfully discharged or otherwise handled a firearm, to wit a .223 Narinko rifle, and or a rifle the make of the firearm unknown to the state, in a manner likely to injure or endanger the safety or property of the general public attending the 5th Economic Freedom Fighters celebration, or residents of Mdantsane and the employees of Gear House, or with reckless disregard for the safety or property of the general public attending the 5th Economic Freedom Fighters celebration, being the residents of Mdantsane and Gear House employees. Count 6 is in respect of accused 2 only, that the accused is guilty of the offence of contravening the provisions of section 120, subsection 10A, read with sections 1, 103, 120, 1A, section 121, read with schedule 4, and section 151 of the Firearms Control Act 60 of 2000, further read with provisions of section 156 of the Criminal Procedure Act 51 of 1977, therefore providing a firearm or ammunition to any person not allowed to possess the same, in that upon or about 28th day of July 2018 and at or near Sisa Dukashe Stadium in Mdantsane in the regional division of the Eastern Cape, the accused did unlawfully supply or in any other manner give possession of a firearm or ammunition, to wit a .223 Narinko Remington bullet, to accused 1, who is not allowed in terms of this act to possess a firearm and or ammunition. Advocate Rhodes confirmed appearance on behalf of accused 1 and accused one confirmed personally to court that he is indeed aware and understand all counts read out into the reports, including the offences that have been explained to him by Advocate, and he is further aware of all relevant or applicable sentence as far as it pertains to the charges. After confirming appearance on behalf of accused 2, accused 2 had also personally to court confirmed that he is indeed aware and understand both counts read out on record, and that it was explained to him by Advocate Matthews. Also, that he was indeed aware and understand all penalty clauses applicable to the charges of this nature, as it was also explained by Advocate Matthews. Accused 1 entered a plea of not guilty to counts 1, 2, 3, 4, and 5. Accused 2 entered a plea of not guilty with regards to counts 2 and 4. My apologies. Not guilty to counts 4 and 6. Advocate Odes confirmed that the plea of not guilty entered by accused 1 with regards to counts 1, 2, 3, 4, and 5 are in accordance with the instructions he had received from his client. Advocate Matthews thereafter confirmed that the plea of not guilty entered by accused 2 in respect of counts 4 and 6 were also in accordance with the instructions he had received from his client. In terms of section 115, subsection 1 of Act 51 of 1977, accused 1 elected not to disclose the basis of his defense and will do so during the course of the trial, and therefore in essence elected to remain silent at that stage. This was also confirmed by accused 1 personally to court. In terms of section 115, subsection 1, Act 51 of 1977, Advocate Matthews informed the court that accused 2 will deny the allegations as per count 4 and 6, and further denies specifically that he handed a firearm or ammunition to accused 1. The plea explanation was confirmed as correct by accused number 2. It should be noted by this court that at this point, Advocate Matthews inquired whether the request for further particulars on behalf of accused 2 and the state's response was attached to the charge sheet. It was not, and on inquiry from the state, being Advocate Caesar informed the court that he was not aware of any further particulars, as it is not contained in the court record or file, but will ascertain this information and provide same to court. I think at this point it will be appropriate then to deal with the request for further particulars, which was submitted by Advocate Matthews at the end of his address before judgment. Therefore, the request is as follows. Advocate Matthews filed a request for further particulars on behalf of accused 2 on the 22nd of June 2020, and in that the request is based on the charge sheet as presented to accused 2 in respect of counts 4 and 6. The defense confirms that they have been supplied with statements A1 to A120 and requested to provide a copy of the document marked A89. Insofar as count 4, the state was requested to inform Advocate Matthews on what the state is relying on to prove that accused 2 failed to take reasonable precautions to to avoid danger to persons or property, including which circumstances the state is relying on to prove there was a risk to the general public, and also in what circumstances or stage of the incident is it alleged that accused 2 had control of a loaded firearm. With regards to count 6, it was requested as to on what acts is the state relying on to prove that accused 2 gave or in any other manner supplied Mr. Julius Malema with a firearm, including a .223 bullet, and also to supply the defense with a statement by Colonel Muko, setting out how he reached this conclusion, including photographic proof of such conclusion as envisaged in the court charts that they were provided with. And the state is also further requested to supply the defense with the results of the muzzle flash test. The above is a summary of the request for further particulars on behalf of accused 2. The state replied to the request on 31 August 2020, and that is confirmed that copies of images, reports, and statements were now supplied to the defense on behalf of accused 2. Further statements obtained after the docket was supplied to the defense is now provided, being A124 to A125. The retake of Mr. Malema's fingerprints and SMP 69s marked A122 and A123. The results of the statements provided to the defense. Further, it was highlighted by the state that A21 was indeed a warning written statement obtained from Tolani Larry Mavundla and is marked as A121, which was obtained on the 5th of November 2019, indicated that he had elected to remain silent, and a copy of A21 will be provided to the defense at the next court appearance. The court was not informed that A21 was not provided to the defense and therefore proceeds on the premises that it has indeed been provided. The previous unmarked statement by Colonel Muko is also now supplied and marked in the docket as A133. A89 is an acknowledgement of receipt attached to the statement of Khaled Nal, marked A85, and also supplied. Compact discs containing recordings and images were supplied to the defense, and that all evidence in possession of the state is now supplied to the defense. In response to count 1, the state replied, Tactical Security Service was the service provider contracted for armed guards, close protection, and the bodyguarding for Mr. Malema at the event. Place and date already placed on record. Further, that Mr. Snyman introduced himself as the owner of the business to the police. Further, that accused 2 handed a rifle that belongs to Tactical Security Services to Mr. Malema, and that Mr. Malema used the rifle to fire shots in the air at a public gathering. Mr. Snyman was present at the time the rifle was fired and retrieved from Mr. Malema. In summary, further, that the Sisa Dukashe Stadium is situated in a built-up area and full of members of the public, the crew working at the stadium and police. Mr. Snyman is also the only, and I quote, white male identified on the stage before and after the shooting of the rifle. Mr. Malema is then seen firing the rifle. There is no statement of a witness in that regard. I emphasize and highlight what I'm reading out now is the response by the state to the request for further particulars by Advocate Matthews, not what was in fact presented. It's the reply that I'm reading. Then with regards to Count 6, the state replied that Tactical Security Services is the owner of rifle CN SPA 249-14. The video footage shows two shooting incidents, the first being the shooting of a handgun and the second incident the shooting of a rifle. Further, after the first shooting incident, the tall African man is seen receiving the handgun from Mr. Malema. He then walks to the back of the stage and the handgun and receives the handgun from Mr. Malema. He then walks to the back of the stage and speaks to the white male standing next to the stairs. At that stage, Mr. Malema is seen dancing on the stage and then turns towards the back of the stage, making a hand gesture or sign. And the white male is then seen at the back of the stage with the rifle, whereafter Mr. Malema is then seen firing the rifle, and Mr. Snyman took the rifle directly after it was fired from Mr. Malema and then moved to the back of the stage. The said firearm CN SPA 249-14 was booked out according to the records of Tactical Security Services to Larry Mavunda, who is an employee of Tactical Security Services and who was also present at the event. Time, date, place already placed on record, my summary. Then on 6 August 2018, the firearm serial number CN SPA 249-14 was presented to Colonel Jansen by Mr. Larry Mavunda with the explanation that the company knew that the South African police services were needed for ballistic testing as a result of an alleged incident. Also that the firearm was not in East London at the time the event was hosted, that it was being sent by accused to, and a cartridge was recovered in the stadium after the incident that is linked to the said firearm CN SPA 249-14. Therefore, the cartridge recovered was fired by the said firearm. Court charts 1 to 7, which was compiled by Colonel Mbwadleka, was also supplied to the defense in this regard, and that statements marked A131 to A133 also now supplied to the defense. In essence, that is the summary of the further particulars that is read with the charge sheet. The state called the following witness to testify and listed by court in no particular order or the order that the state witness were called to testify, but in an attempt to differentiate between the various witnesses and their occupation at the time. Therefore, the court had attempted to list them accordingly, being firstly Ntombi Fikile Mankomo, a cleaner at the time of the alleged incident; Nomfundo Rwana, the supervisor of the above-mentioned employee; Jonathan Kumalu, assistant manager at the time; the police officers who testified in no particular order being Colonel Nkwali, the SAPS member in charge of the EFF 5th celebration; Captain Swart, the member of SAPS who retrieved or received the spent cartridge in question; Lieutenant Colonel Janssen of the Provincial Firearm, Liquor and Second-Hand Goods Unit. Warrant Officer Becker, a witness that attended the alleged crime scene. Colonel Ngwadleka, attached to the ballistic section of Sept in Port Elizabeth. I refer to it as Port Elizabeth as it was still Port Elizabeth in the year 2018. Captain Mzuku, a Cluster Communication Officer of SAPS in East London. Captain Creer, the recipient of 3 batches of firearms. Warrant Officer Steenkamp, a qualified facial identification specialist. Captain Botha, attached to the Cybercrime Investigation Unit. Captain Govender, at the time, a Media Center Controller and Spokesperson. Colonel Swartboy, being the investigating officer of the matter before court. And Dwayne Francis, a digital forensic investigator at the time. The state further called Sydney Stander, the regional manager, Eastern Cape of SIRA, Private Security Industry Regulating Authority. And with regards to the Gear House Company employees, Sibusiso Ngogo, an audio-visual technician employed by Gear House at the time of the incident. Ashley Singh, the branch manager of Gear House at the time. And Samuel Quater, a senior audio-visual technician employed by Gear House at the time. The defense opted to follow accused 2, to allow accused 2 to present evidence ahead of accused 1, and in this regard, the following witnesses were called during the defense case on behalf of accused 2. Mr. Martin Wood, an attorney by profession, and also responsible for the firearm-related issues pertaining to tactical security services, and also contributed to the drafting of the legislation of the Firearms Control Act 60 of 2000. It was followed by the evidence of Mr. de Klerk, which the court will refer to as the ballistic defense expert, if so declared by court during these proceedings at an appropriate stage. That concluded the evidence presented on behalf of accused 2. The defense for accused 1 opened the defense case and called accused 1 to testify. After the evidence of accused 1, the following list of exhibits of the state, with the consent of the state and the defense, the contents with which the court will deal at the appropriate time, was submitted by the defense for accused 1. I will deal with all the exhibits presented and by chronological order, if that would be more sensible. Firstly, the following exhibits has been placed before court. Exhibit A, depicting a photo of the sealed cartridge retrieved from the scene. Exhibit A1 and A2, photos depicting the spent cartridge that was retrieved on the premises, and an enlarged photo pertaining to the structure. Exhibit B, an affidavit drafted by Mr. Stander pertaining to one Mr. Mabunda. Exhibit B1, affidavit deposed by Mr. Stander pertaining to Mr. Snyman. Exhibit C, the statement and report of Captain Janssen, which was accepted by consent of all parties. Exhibit D, the sworn affidavit drafted by Warrant Officer Philip Becker. Exhibit D1, photo album and key drafted by Warrant Officer Becker. Exhibit D2, photo album and key drafted by Warrant Officer Becker. Exhibit D3, video footage, still images drafted by Warrant Officer Becker. Oh no, there is a clear rule of no still photos during the court hearing session, please. Exhibit D4 was the submitting of the evidence of filler packet and confirmed by the witness Vincent Muko. Exhibit E, the forensic ballistic document drafted by Colonel Nkwadleka. Exhibit E1, exhibits for ballistic analysis that will include Exhibit E2, Exhibit E3, Exhibit E4, E5, E6, E8, Exhibit E9, including Exhibit E10. All pertains to the ballistic reports by Colonel Nkwadleka, and the court will deal with the contents thereof in full. All of these said reports were submitted during the evidence of Colonel Nkwadleka. Exhibit F is also, that was marked as the court charts compiled by Colonel Nkwadleka, depicting 7 pages of court charts. Exhibit G, an affidavit deposed by Muko Vincent Muzuko. Exhibit H, report compiled by Sergeant Dwayne Francis regarding mobile phone analysis. Exhibit I, the report and affidavit drafted by Warrant Officer Steenkamp, the facial and identification expert. Exhibit J, the report compiled by Captain Adriaan Snyman from Cybercrime and the Forensic Unit. Exhibit K1 and K2 are both statements submitted during the cross-examination of Captain Marley Govender. Exhibit L, the fire compliance. It is in the form of a letter pertaining to tactical security services indicating that they are indeed compliant. And Exhibit L2 is a letter drafted by the NPA to General Masemola. Defense exhibits was Exhibit M, being the affidavit and report compiled by Mr. Jan de Klerk during the evidence of accused number 1. The following written statements were submitted: an affidavit compiled by Andile Kumar, affidavit compiled by Lungisa and Zeleni, affidavit compiled by Pia Kare, affidavit compiled by Thomas Chauke, affidavit compiled by Mengu Vera. That's the best I can pronounce it. As stated, I need to repeat evidence and certain aspects in cross-examination which will be relevant when the court arrives at its reasoning and finding. So I cannot skip any portions of this. I will firstly deal with the evidence of Tom Fikile Makoma. She testified she's employed on a contractual basis at Buffalo City Municipality as a cleaner at the Sisa Dukashe Stadium in Mdantsane. She was on duty on 30 July 2018. Since she formed part of the team who had to clean the stadium after the EFF rally that was held on 28 July 2018, the witness and one Kumeza walked onto the field in the same direction and started to clean the field area. It was dirty and they picked up screws, bolts, bones and dirt. As she got close to the lamppost, she picked up a cartridge and showed it to Kumeza and said the reason why she called her, I quote, is it is the first time for her to see such a big 1. That I quote verbatim. In essence then, the size of the cartridge picked up is one she has not seen before. She called the others who also came to have a look, and a male person from disaster management was also present at the field and called her to bring the cartridge to him, which she did, and he placed it on a small table that was in the back of his buggy that he was driving, and took various photos of the cartridge and handed it back to her and told her to hand it to her supervisor. The cartridge was then handed to Mfundo Lwane, who was told to put it in her office. The lamppost the witness is referring to is the lamppost which is on the field, on the grass surface. A photograph of the cartridge was shown to the witness, who testified that it is indeed a cartridge and no other cartridge found that day except for the one picked up and shown to her in court. Exhibit A was shown. The witness indicated that she can identify the spot where she found the cartridge and marked the photograph using an X mark, and testified that the caterer's tent was at the spot where the cartridge was picked up by her. She explained that there were stands there and a tent, as well as a passage that divided the tent room from the podium. At the time she testified that the cleaning tent had been removed and stand was being removed or dismantled, and the two pillars where the words 5 years were written on or depicted had also already been removed. She further explains that the photograph depicts Sisa Dukashe Stadium, and the first gate on photo number 1 is a small gate which they used to enter, and there are palm trees on the outside of the stadium. Photo 2 depicts the field that faces the grandstand, which is not visible on the photo, and shows the trees towering over the field, and the pole depicted in the photo is the one where she picked up the cartridge, and that there are only 2 lampposts at the stadium, one on the field which she pointed out and where she picked up the cartridge, and the first pole is on the one right at the spot as soon as a person enters the first gate. She testified that photo 5 depicts the corner of the entrance. A total of 8 photos were shown to the witness. Cross-examination by Advocate Hodes on behalf of accused 1. She confirmed that she attended the event on 28 July 2018 and she was also on duty at the said date. She confirmed that she knows how the stage was set up, as it was already set up during the course of the week before the event. She further confirmed that the photo shows that the stage had been removed and the floor was the last item that was to be removed. She is unable to estimate distances and testifies that she is illiterate and that the X she marked on the photo album to her is not marked on the tent as depicted, but indicates, according to her, the area at the lamppost where she picked up the cartridge. And she concedes that the X could be where the tent was erected, but the passage was not in front of the stage but in between. She does not know who put it there, and she picked it up as it is her job to do so and clean. There were no cross-examination on behalf of accused 2 by Advocate Hodes, no re-examination by the state. On questions by court, she stated that she was alarmed when she picked up the cartridge because of the size of the cartridge, the color, and the sharp point of the cartridge. There were no questions following the questions by court on the side of the state or the defense, and finalized the evidence of the witness. Court will will deal with the evidence of Nomfundo Luwane, also an employee at Buffalo City Municipality in the capacity of a supervisor. Her duties include supervising cleaning staff and to instruct them as to where and how to work and to ensure that the instructions are complied with. She arrived at work at 8 a.m. on Monday, 30 July 2018, and on her arrival, she instructed the workers to go and clean the premises where the EFF held a celebratory event at which the witness, Ms. Luwane, also attended on 28 July 2018, and she had remained present for the duration of the day. And after arrival at 7 a.m., she left at plus minus 6 p.m., checking that all ablution facilities were clean and overall supervision was done. On 30 July 2018, she instructed employees to go to the premises where the event was held to clean, and on going back to check whether the stadium was being cleaned, one of the employees, Fumeza, came to her saying she had picked up a cartridge and she told Fumeza to go and put it in her office. She only looked at the cartridge in Fumeza's hand. Exhibit A1 was shown to the witness, who confirmed that by mere looking at the photograph that it was the same length as the one Fumeza had shown her on the day in question. The cartridge was placed in her desk drawer and she received a phone call from South African Police Services asking whether a cartridge had been found. She had placed the cartridge in the drawer of the reception desk then, and when police arrived, she handed the cartridge to the police official, whose name she could not recall, but is able to identify. She further confirmed that one cartridge was given or shown to her on 30 July 2018 at about 13 p.m. I may add that the cartridge was in fact a member of Sept's. The witness is referring to would be the evidence of Captain Swart, which the court will deal with shortly. During cross-examination by Advocate Odes on behalf of Accused 1, the witness stated that it may indeed be any cartridge according to her view, as she saw nothing else peculiar. During cross-examination by Advocate Matthews on behalf of Accused 2, the witness confirmed she made a statement to the police on 1 August 2018, the same day that Sept collected the cartridge. She denied certain facts contained in her statement. Example, that they were seated when she was shown the cartridge, which the witness denied, stating she was standing and she was shown where the cartridge was picked up next to the stand. In essence, that was the only aspect in cross-examination that was challenged. It follows by the evidence of Jotham Kumalu, employed at Buffalo City Municipality at the Disaster Management Unit in East London. He was also on duty on 28 July 2018 at Sisa Dukashe Stadium in Mdantsane, where the EFF event was celebrated. Part of his duties entailed the planning of the meetings pertaining to safety and security meetings, and in general all safety and security aspects. He confirmed that prior to the event, meetings were held at the venue and it was chaired by Colonel Mkwali. He testified that he attended a meeting at the venue 3 days before the event. He also visited the venue the day before the event to ensure all safety and security measures were in place and to ensure that all the structures were in place and ensuring that no emergency exits were blocked, and received a temporary certificate from an engineer. He testified that on the 27th of July 2018, he was satisfied that all was in place and only the structural certificate for the stage was still outstanding. as it was still being constructed at the time. He returned to the venue on 28 July 2018 at about 7 a.m. and was handed the structural certificate, and everything was found to be in order as arranged for the event. He testified that the event went well as all participants had cooperated with one another and because of the discipline displayed by all participants. He recalls that someone was injured at the stadium, but that an ambulance was present according to him, they did not have any real problems at all. Say was injured. He did not refer to being injured as a result of the incident. I accept that someone somewhere may have sustained an injury. During the evening of 28 July 2018 at about 19:30 p.m., the final VOC meeting was held as an opening meeting and then again a specific one for closing of the meeting, and a debriefing session was held. He testified that the music stopped at about 19:30 p.m. and the people started to sing thereafter, and they did not have a problem with that at all. He heard a crackling sound, however, the meeting briefly paused and thereafter it continued, and he left and he went home. He described the loud sound as similar to the sound of fireworks. He returned to the venue on 30 July 2018 for a post-event inspection and arrived at about 11 a.m. He was walking along a fence, inspecting the extent of damage to the fence, when a general worker called him and he was shown a cartridge. He confirmed that he took photographs thereof and instructed the general worker to hand it to a supervisor. He confirmed that Exhibit A1 was photographed by him. It depicts the back of the cartridge and the numbers are visible and appears to depict my notes 223, but unable to see the marking clearly. Cross-examination on behalf of accused one by Advocate Hodes. The witness confirmed that he was involved in the pre- and post-assessment and all was in order, including post-event, and only a gate at the emergency exit was slightly bent, and it was the only issue tabled. No record of any shooting was made, and the only sound he heard was the one he had explained regarding the fireworks, and he explained it as fireworks that one sees on New Year's Day, and including the sound thereof, which no report was made about. The arrangements was that the music will stop at 8 o'clock, however it went on a little longer until at 7 o'clock, until before 8 p.m. and he left whilst people were still present, and he did not have any incident to report on. He confirmed that he was handed a cartridge by one of the general workers, which he photographed, but he did not ask the name of the lady who showed him the cartridge. He also did not seal it in an evidence bag, since he did not know if it will be needed later and for what reason. The VOC meeting was held and the speaker talking stopped until the sound of the fireworks was quiet in the VOC room, and again the meeting continued. The colonel present asked what was that sound, but no one knew since none of them looked, and that concluded the evidence of the witness. The court will now deal with the evidence of Captain Johannes Sept. captain in the South African Police Services stationed at Mdantsane Police Station. He testified that on the date of 1 August 2018, he was a warrant officer attached to the detective branch at Mdantsane, and he was also on duty on the 1st of August 2018, and he was told to go to Sisa Dukashe Stadium as a shooting had taken place and a cartridge casing had been picked up. On arrival at the stadium, he was handed a cartridge by the cleaning section supervisor and sealed it in evidence bag with seal number PA 6001796 6106, and he handed the sealed exhibit bag to Colonel Swartboy. He testified that in as far as it is within his knowledge, it was a rifle cartridge, example an R5 or an AK-47, but definitely not a pistol cartridge. The cartridge was handed to him at the stadium by Mr. Wane, and photos were taken of the sealed exhibit bag containing the cartridge in the presence of the witness. The witness was shown exhibit A, and he confirmed that it was the cartridge that was found and handed to him in the sealed exhibit bag. He also confirmed that the photograph depicting the sealed evidence bag is indeed correct, the correct exhibit according to the serial number reflected. Cross-examination by Advocate Holders on behalf of accused 1 confirms he placed the cartridge in the exhibit bag whilst he was still at the Sisa Dukashe Stadium, and recalls that it was done in the presence of the witness. It was placed before the witness that Mr. Wane did not testify regarding that, and he had no comment to that statement made. He did not obtain the statement or affidavit from Mr. Wane. He, however, states that he sealed the cartridge exhibit bag in front of the lady who had handed him the cartridge. He further confirms that that is the point where the chain evidence started, and that is crucial that the seal number of any exhibit be kept intact at all times. That is the point where the chain evidence started, and that is crucial that the seal number of any exhibit be kept intact at all times, and that there was no chain of custody until it was received by him. The witness also confirms that it is similar size to a 7.62 cartridge, but that it was indeed a rifle cartridge that he was handed. During cross-examination by Advocate Matthews, Let me rephrase the paragraph I've just read out, starting as from. Confirms he placed the cartridge in exhibit bag while he was still at the Sisa Dukashe Stadium, and recalls that it was done in the presence of the witness. That is the start of cross-examination by Advocate Holders on behalf of the court. It was placed before the witness that Mr. Wane did not testify regarding that, and the witness had no comment to that statement made to him. He did not obtain the statement by or from Mr. Wane. He, however, states that he sealed the cartridge exhibit bag in front of the lady who had handed him the cartridge. Further confirms that it's the point where the chain evidence started, and that is crucial that the seal number of any exhibit be kept intact at all times, and that there was no chain of custody until he was received by him. The witness also confirms that it is a similar size to a .762 cartridge, but that it was indeed a rifle cartridge that he was handed. That was the cross-examination on behalf of accused 1. Cross-examination by Advocate Matthews on behalf of accused 2. He testified the cartridge looked similar. The cartridge that he was shown does look similar, but the one he was handed is a rifle cartridge, that concluded the evidence of Captain Swat. Now I just have The court will now proceed to deal with the evidence of the witnesses as far as it pertains to the gear house employees. And I will start with the evidence of Mr. Ashley Singh. The witness testified that on 28 July 2018, he was employed at Gear House Company as the branch manager. His day-to-day responsibilities included all operational and financial elements, including the delivery of technical services that being in the events industry. Therefore, he manages the branch and all operational activities. The company provides technical support to live events industry. Technical elements will include sound, audio-visual, lighting, staging, and power. The company also provides for stage settings, for structures, but not tents. He testified that the company provided the services on 28 July 2018 at the EFF's 5th celebration. However, he did not personally attend the event and was not present in East London. The employees from Gear House Company were sent. In total, 18 were sent to assist with the event mentioned, and in his view, the relevant persons for this matter will be Sisa Dukashe and Samuel Kwata. Those two being part of the 18 employees that were sent. He explained that Mr. Dukashe was an audio-visual technician, but on this specific event, he provided the role of the vision mixer. Therefore, he handled the feed of the cameras onto the big screens, and the role of Mr. Kwata was also an audio-visual technician, and the role he also had to play at the event was to play content onto the screens. The employees who attended the event remained in contact with the witness as they had created a WhatsApp group and also communicated telephonically. He testified that the audio-visual equipment, lighting, and what he refers to as rigging and cabling would have been packed up after completion of the show, which would have been late Saturday night, and the structures part would have been packed up by the Monday. None of the employees who dealt with the packing up of the structures contacted him on the Monday according to his recollection. The witness confirmed that he was telephonically contacted by Brigadier Govender on the 8th of August 2018, attached to the Eastern Cape Directorate for Priority Crimes Investigations. He was informed by the Sept member that he was investigating the matter and that he needed to physically inspect the stage or structure. The witness believes that the police official could well not have understood the term, I quote, stage, since he informed him that the actual stage does not exist anymore. It will have to be physically built or erected, and that the stage did not exist as it was done at the event and would need to be reconstructed fully. He was informed that the official wanted to physically visit the offices and also inspect the equipment used at the event. The police official was under the impression that the stage would have incurred damages as a result of the shooting on site and therefore wanted to look for physical damage or other kinds of evidence. The witness informed the police officer that he was not part of the staging department and therefore the official should contact the head of the structures department. The official agreed and informed the witness that he will send a team of police officials to the office to inspect the stage, which I refer to as the stage. A few days later, a team of police officials arrived who inspected the equipment with an employee from Gearhouse, one Mr. Madlala. However, no damage was observed. Thereafter, the witness, with the staging head of department, looked through the stage as well as the footage from the event to ensure that none of the roof skins were damaged, as it would compromise the integrity of the structures going forward. He was told by the head of his department that there was a shooting on site and it could have come from there, hence the checking that followed. He then viewed the video, which is referred to, I would believe, as video clip 1 and 2, termed the Gearhouse footage. At this point, the witness was asked to move out from the witness stand and to come closer, and 2 video clips were played in court. On questions pertaining to these footages viewed, the witness testified that he saw from the angle of the stage right camera, I quote, obviously someone firing a firearm, but it was done away from the stage, what we call a skin. So at that stage, I was relatively comfortable that no damage would have happened to the roof itself, quoted verbatim, page 52 of the record. He does not know how many shots were fired or how many times the person he had observed moved to the side of the stage. The witness confirmed that the video he had just viewed in court is the same footage he had produced at their offices of the recording of the event. He received the recording footage from the audio-visual department. He explains that in the scope of their work, they were asked to record the event, and therefore he went through the footage of the event as they were asked to record the event. He requested the footage and testifies that the footage of events as recorded in segments viewed in court, as it depends on the capacity of the memory card, on the camera, and of the recording device. So they had about 3 or 4 segments of the total show, starting from midday until the event closed. The further reason why the witness decided to view the recorded footage was it was easier to do so than to rebuild the whole structure, because it would be an intensive 3-day exercise, and after watching the footage, we asked that the actual skins of the roof be pulled out to check for damages, and on looking we were satisfied and comfortable that indeed no damage had been occurred. He testified that at the same time he watched the recording, he was not able to identify the person who was firing shots. After viewing of the footage and checking the roof skins of the tent, he informed Brigadier Governor that they had not incurred any damage, and the police official then requested the video recording footage of the event, and that he had wanted to view the recording. A team of police officials was again sent to Gearhouse Company, and the video recording or footage was viewed, and he assumed they would then report back to Brigadier Governor. However, they requested that the footage be handed to them immediately, and the witness informed them that he would need to contact his legal department for advice, which he had done, and was advised by the legal department that the law enforcement officials will need to provide the relevant documentation in terms of section 205 of Act 51 of 1977. To obtain a copy of the footage. After a few days, the law enforcement members returned and handed the relevant documentation, including that of the Section 205 subpoena, to the witness for the law enforcement members to look at the footage and to be given a copy. He was present when this was done and when the footage was downloaded by Mr. Quata, and after the footage was downloaded, the footage was sealed by the police officials in the presence of the witness. He also confirmed that Mr. Quata downloaded the footage from the laptop that they used at the show. He confirmed that while the footage was in their or his possession, it had not been tampered with in any manner. He is able to say so with confidence as the footage was locked in the company safe on the premises, and he was the only person with access to it and only opened it again when the lady from the forensic unit came to the offices. The witness also continues to say he is able to confirm that the footage that was handed to the law enforcement officials and which was sealed in his presence is indeed the recorded footage, and that it is indeed a part of the footage that was handed to the police. He explained it was a part, meaning that they had handed the police a comprehensive recording of the event, and that is obvious that was what had been viewed in segments or part of segments of the event itself, as testified to by the witness. This is quoted verbatim. Cross-examination by Advocate Odes on behalf of Plea 1. The witness again confirmed that he was not present at the said event in question. The first time he heard about the matter is when he was approached by Brigadier Governor during a telephonic call. Further, that he was informed that the intention of the law enforcement members was to inspect the actual stage and the roof covers, since if it had been damaged, it would impact on the integrity of the covers for future events. The witness made it clear that after he was told by Advocate Odes that he had inspected the covers very thoroughly, that he had not done so, his staff had done so, but he was satisfied that no damage had been reported, and if there had been, they would have reported the same. It was put to the witness that he does not have any idea as to what time the event started. Verbatim, page 62 of the record, and he replied he has a rough estimate of the time being around midday and ended after 2300 hours being 11 p.m. It was then put to the witness that it is the fact that according to the one of his employees, who the court will still deal with, one Mr. Ngobo, the event started before midday, to which the witness replied it may very well be true, and further placed before the witness that, I quote, not having been there, he has no personal knowledge of the events. And he had agreed with Advocate Odes that he was relying on information passed via communication channels. The witness confirmed that the entire event was recorded from beginning to end, and on being asked as to who extracted snippets from the recording, the witness replied he would assume that it was the law enforcement officials. He was then told in clear terms by Advocate Odes that he is not entitled to assume and to not interrupt him whilst he is still speaking to the witness. Therefore, that issue was not pursued, and it was followed by the following statement made to the witness, page 63 of the record. I quote, You were called to explain to this court the procedure followed in the extraction of the footage because you were there. Who made the decision, sir? The witness replied by saying, I do not believe any decision was made to extract the segment. I believe we downloaded the entire footage, unless I am understanding your question incorrectly. After several questions, the witness confirmed the following, that indeed the entire recording, as per the evidence and statements placed before him, would amount to around 12 to 13 hours of recorded footage, and confirmed that he does not know who extracted the snippets from the footage that he viewed in court. And confirmed that what he had viewed, the footage what he had viewed in court was a segment of which he had handed over to the Hawks. And he confirmed it as such. The defense stated on record that it is indeed so that it is not possible to view 12 to 13 hours of footage in court, and the witness agreed to that statement and that he played no part in the extraction of the footage viewed in court. The witness was told that when the members of the Hawks came to your office on the first occasion and requested the footage, they did not have a Section 205 subpoena with them, which the witness confirmed. The witness testified that on hearing the request by the Hawks, he decided to obtain legal advice and was informed that the procedure was indeed to be followed as to obtain a Section 205 subpoena, which had to be obtained by the law enforcement officials. The witness testified that he was not shocked on hearing the request. He was, however, surprised as he is not clued up on the legal process, and as he was unaware of what to do, he sought legal advice for that reason. Cross-examination of accused 1 continued. It was then put to the witness that with regards to the law enforcement officials, I quote, prior to that, none of them had mentioned to you what procedure ought to be followed. Is that correct? The witness replied that he does not recollect. The issue was pursued and the witness was informed that it is clear he had testified that he was requested to hand over the footage of the event to the Hawks, and he had opted to obtain legal advice. Therefore, it is clear that it was not explained to him, which the witness then agreed to. In closing, the witness confirmed that he is not able to identify the person in the footage who was referred to by the defense as the shooter. Cross-examination by Advocate Holders on behalf of accused 1. The witness confirmed that he testified that Mr. Quata downloaded the footage from a laptop onto a hard drive, which was handed over to the Hawks. The said laptop had subsequently been stolen. That comparison to the original at this stage is not possible. It was further pursued and placed before the witness that if I, as the defense, I quote, on behalf of my client, would want to verify that what we are watching is the correct video, it is not possible. Correct? The witness replied to, you would say that it is correct, however, the last time would have been original when it was handed over, unquote, verbatim, page 70 of the report. He confirmed the evidence of Mr. Ngobo placed before him, that Mr. Ngobo was called to a meeting with the Hawks at their premises. The witness clearly answered that there were a few meetings. Initially, then a few meetings where initially all of their statements were obtained, and they were kept separate and treated separately whilst their statements were obtained. The witness cannot comment on the statement placed before him that Mr. Ngobo testified that he was shown the first clip and not the second clip by the Hawks, as he was not present when it was done. And as to why he was not present, he explained he may have been busy with work, attending an event, and there had been a few meetings with the Hawks. It was put to the witness that the defense is concerned about the fact that the laptop in question had been stolen, and the witness explained that he is able to draw a diagram and explain to the defense about the concern raised. But per the record, page 71, the defense, being Advocate Matthews, informed him, no, I just want to know how did the laptop go missing. Page 71, the witness replies to say, oh, it's quite common. It's quite a common thing in our industry. It is a high commodity item, so it moves from job to job, and people obviously nick it because it is easy to conceal and put under the jacket and walk out with. He confirmed that he was not told to preserve the laptop, but he was told to preserve the hard drive, which he had done. He testified that he believes the theft of the laptop would have been reported to SAPS, as it is standard procedure for their company to do so, and that he would believe that it was done as they would require a police CAS number for insurance purposes. There was no re-examination by court, by the state, and questions by the court. The witness informed the court that the stolen laptop was the property of Gear's company, and by checking the serial number, is able to say that the footage downloaded or recorded by Mr. Ngobo onto a hard drive is the laptop that was subsequently stolen. He had corrected the court by saying that it was downloaded by Mr. Kwata and not by Mr. Ngobo, as stated to him by court, and he had corrected the court quite correctly so. The witness also informed the court that the hard drive had not been stolen and that the initial download of the footage is still in the possession of Kia's company, being, I quote, the hard drive was not stolen. So there is still a hard drive, the initial one, the initial downloaded one. It is in their possession, page 74. The witness informed the court that in all honesty, he would have rather not be in court for this matter, and explained that one might construe it to be awkward for me, and that the witness further informed the court that this incident was the first time for him to engage with any law enforcement officials, and the procedures to be followed on handing over of video footage to law enforcement officials. He also explained that one of the reasons or motivation for seeking legal assistance or advice was, firstly, before handing over the footage, was that it would be detrimental for the business having that equipment impounded or whatever else, unquote. And secondly, as it involves a client, an employee must make sure that they are not infringing on anyone's rights or doing anything wrong, and confirmed he had done so to testify himself that he had complied with what was required of him to do, as he does not have absolute power in his capacity as branch manager and did not want to overstep his limits. That concluded the evidence of Mr. Singh. Was followed by the evidence of Sibusiso Ngoba. Testified he was employed at Gia's company 28 July 2018 based in the KZN province and employed as an audio and visual technician. He explained that Gia's company deals with live events and the company provides stage structures, sound and audio visual equipment for events. He stated that his qualifications are that of a qualified audio visual technician, and at the time of his evidence he had 7 years experience in this field. The witness confirmed that he was contracted to come to East London for work purposes for the event held on 28 July 2018, and he was contracted to come and do everything pertaining to audio-visual. That is quoted verbatim, page 14 of the record, meaning from set-up of the equipment, operating of the equipment, including the recording of the content that was taken on that day, unquote, page 14. He further explained that during the event, they had 2 cameras. One camera was on the stage right, which means when you are at the stage facing the crowd, or on the stage facing the crowd, it is on your left. It is called stage right in their terminology. And then another camera was at the, what they call front of house. Front of house is the tower that is built opposite the stage, about 35 meters away from the stage. It is called front house. It is where all the engineers who are operating the show are seated, so they are able to have a clear picture of what is happening on the stage. For that reason, one camera was placed there. We also set up a vision mixer called a HS400, which he uses to mix the cameras, and he was using the set equipment on the set day. On further explanation, the witness testified that a vision mixer means it is when, I quote, take the feed from the cameras, it is used to mix cameras. So those 2 cameras are installed in my vision mixer, and I'm able to see them in my monitor screen, and I'm able to switch in between using the vision mixer. He also added what he refers to as an capital ATEM studio that was used to record that feed from the vision mixer. He also had an ATM studio that was used to record the feed from, I've repeated that. Which means whatever he is busy mixing on the vision mixer will go through the ATEM studio that he was using to record, and it was being recorded using the said ATEM studio, and he was also responsible to give the feed to the big screens that were on the venue, so the crowd would also be able to see the content. They started to set up the equipment at about 8 a.m. on 28 July 2018 at the Sisa Dukashe Stadium, Mdantsane. His task was to ensure that he gets the correct feed from the cameras, and he will communicate with his camera operators using, which I will refer to as comms, COMMS, and explain as an example. You would tell them that camera 1, please stand by. He will be going live, or camera 1 will be live. And then just like that, I quote, camera live would go live, And that is so because there's a great working relationship between him and the camera operators. He confirmed that he was personally involved in setting up of the equipment, and he set up all the equipment on site with the help of the other technicians. The witness explained that the reason why he tells or he calls camera 1, or he tells camera 1 that he's coming to camera 2 or 1 or 2, etc., is to ensure that the camera can move when he calls them live on screen, so to ensure they are ready to log onto a shot that you will now be able to move the camera once he's live. The technician will understand that he is now live. During the event, his focus remains on the monitor in front of him, and he can mostly observe what is on the screen most of the time. He does not have a vision of the stage as it is about 35 meters away. Therefore, his focus is on the monitor in front of him with the cameras on. He was also present for the duration of the event and was recording the event. He also confirms that he saw Mr. Malema, accused 1, at the event, since he was the main speaker at the event, and that he had recorded everything that had happened at that event. He further testified that he does not know accused number 2, Mr. Snyman. However, he saw him at the event on the day in question. He, however, does not record exactly where he saw accused number 2, as he was busy recording the event. He continues to say that all he can recall about the incident is that there were a lot of singing and dancing. And he did not see any shooting incident on 28 July 2018 at the event. He explains that when he's mixing, he uses comms and it covers both his ears, so it blocks any banging sounds from the front. Therefore, he cannot comment on whether he heard the firework display on the day of the incident. He also did not observe the firework display that evening. The event ended, according to him, at about between 10 to 11 p.m. and he was also asked to record what is called the after party. The state asked the witness what happened once he had recorded whatever he needed to record and what happens to the footage or happened to the footage he recorded. The witness explained that once he finishes with the recording, he will then check that the recording was done. He then also double checks that the recording is there on his laptop and thereafter on the hard drive, which he was using to record on, and then he will browse through the recording to check if there is audio and that there are no glitches. Then he will submit the hard drive with the content of the recording to the project's manager from House Company, who will be on site and confirms he did so on the particular evening. In fact, he testified to say he did so as it is procedure. As to how he became involved in this matter, the witness testified and explained that a few days after the event, officials from either NPA or the Hawks arrived at the office of House in KZN, and he was asked to join them because they requested a meeting with those persons who were working at the particular event. And that is where his involvement started in this matter. And also how he came to be a witness in this case. He also confirmed that the purpose for the visit from the Hawks was, according to the witness, that they firstly wanted to make sure that he was indeed the person who was doing the recording first, and they asked questions about the video and if it is original or what was the process that took place. The project manager at this time was one Lifa, and he was from the Gauteng House offices. The witness stated that whilst the video footage was in his possession, he had not tampered with the said footage, and in his view, there was no tampering with the footage whilst in his possession. At this point, the footage was played in court, including a video clip, including a second video clip that was shown to the witness. The witness testified that he indeed recognizes the footage as it is or was the footage from the two cameras that he was mixing from on that day. He continued to state that it was two cameras as it shows it was taken from two camera angles that he used to mix on that specific camera. He confirmed that he has viewed the first video footage before whilst the Hawks were present, but he has not seen the second clip before court, before today, that day before. He explained that the Hawks informed him that they were going to use their video footage as evidence, and they asked him to view and observe the footage, after which they asked him if he had observed whatever happened in the first video. It is how he became aware or viewed the first video clip. The witness confirmed that the video footage he viewed in the presence of the Hawks was indeed the footage recorded by Gearhouse and which was provided by Gearhouse to the Hawks, and that it is what he has seen in court whilst viewing video clip 1 in court as the same that was provided, and more precisely, it is part of the footage provided by Gearhouse to the Hawks, which he viewed and confirmed to be the footage provided by Gearhouse to the Hawks, as he viewed it with the Hawks and in court. He was not informed by the police or a colleague about any shooting incident, or that police will visit their office before the time. He only became aware when the Hawks arrived at their offices in KZN. The third video clip was played and viewed by the witness in court, and he testified that their company did not have a camera from behind the stage, and that it was not recorded by their company. And on being asked by the state what the difference was between the three sets of footage viewed by the witness, he replied that he did not know where the third recording came from. Thereof, only the video footage pertaining to the first and second video footage played in court, he can confirm that it was recorded by him, as it is from the cameras that he used to set up from the stage right and from the front house. So as he confirms that he is personally aware and has personal knowledge about the first and second video footage viewed, and the court quotes verbatim, I quote, "But on the first two, 1 and 2, it is from the cameras that I set up from stage right and from the front of house. So I know them personally," unquote. Page 23 of the record. The witness confirmed that the setup of the stage as depicted in the video clips of the footage is exactly the same as reflected in the first and second video clip, and which was recorded by him. Cross-examination by Advocate Houdes on behalf of accused 1. He testified that the two cameramen on the day in question was on the stage right, Sanele and Jobu, and the camera at the front of the house was one Mdumise, surname he cannot recall, as they are no longer employed at their house, and he does not know their whereabouts. It was then put to the witness, and the court will quote as follows: "So basically, you admit to this court that you did not operate those cameras and those respective people, Sanele and Ndumisa, operated the cameras on the night in question, and the witness then replied and stated that that is correct, and conceded that he had not controlled the cameras. He agreed that he did not watch what was happening on the stage most of the time, and the court may add that it was also put to the witness that is how his evidence is understood by the defense to appear, which he had conceded to, and not which he had testified to. He confirmed that he was approached and requested to depose of a statement. It was put to the witness that he had made it clear in the statement that he was not the cameraman responsible for the filming of this incident, to which the witness answered correct. It was further placed or put to the witness by advocate holders, I quote, and once you were shown the video footage at a subsequent stage of your own report, you said you were not certain whether it was a real or toy firearm. On this aspect, the court must comment that statement is not part of the record presented or testified to by this witness. He was then asked, do you confirm that, sir? Is that correct? And he replied, correct. It was then stated that you went further, sir, and you said that having only watched this on a monitoring screen, you were incapable of deciding or determining whether it was in fact a toy or a real firearm. Is that correct? Page 27. Again, the court needs to highlight that that statement was not emanating from the evidence of this witness. It was merely put as facts, but not as a statement emanating from his evidence. It was further placed before the witness that the instructions from accused 1 is that the firearms that you saw there on screen were screen or TV firearms that are incapable of firing projectiles, at which the witness asked advocate holders to please repeat the statement placed before him, which was then repeated and placed before the witness, and the witness replied by stating clearly that he had no comment, I do not know, unquote, verbatim. Further, quoted, if I were to show you these items that were utilized for similar items, we refer to them in legal terms as facsimiles, copies, for the actual items that were utilized that night, would you be able to identify them from what you saw that night? The witness replied that I do not know, to which the defense answered, I beg your pardon? This caused the witness to pause and ask, sorry, will you please repeat which items are we talking about? It was not repeated, and cross-examination continued in the following fashion. It was put to the witness as follows. If I brought to court those screen or TV firearms that cannot eject a missile, should be a projectile, nothing comes out of them, would you be able to identify them or not? The witness replied, no, I will not, followed by the question of the defense, why? The witness explained that he was not focusing on them. I do not even know how they look like, even the color or anything. Up until today, I do not know. It was then placed to the witness by advocate holders that, surprisingly, it is depicted, I would assume on the footage viewed, nobody ran or was afraid that they might be shot from what you have seen. And the witness had replied he had no comment. The response was not accepted by Advocates, and it was put to the witness, no, you cannot, with respect, sir, say you did not observe the people's reaction. You have watched the video. The court has watched the reaction. I put it to you that nobody ran away from these firearms or expressed any fear whatsoever. Do you have any comment? The witness replied by saying he was just flighting the image, that being the content on screen, so he was not even looking at the reaction of the people, because even when the Hawks came to show him the video, he was still not looking at the reaction of the people. So that is why he says he cannot comment. His interest was not on that when he was looking at the video. I need to, and it will become apparent later, the issue was further pursued with the witness after he had replied to the statement made by Advocates, that it was still not accepted by the defense, and Advocates continued to put the following to the witness. I quote, you watched it in court, you have watched it before. I put it to you, in other words, I challenge you, that nobody runs away at the time of the so-called firing of these items. Do you have any comment? At this point now the witness answers by saying, I quote, I did not see anyone run. A remark was made by the defense then, yes, it is obvious we all watched it. Questions then returned to the video footage, and the witness agreed that the footage does not reflect a gear house logo, and that the clips viewed in court appears to be extracts of the event of that night, and that the event began at plus minus 9 a.m. that morning, that there was a main spokesperson, all which is not shown on the video footage viewed in court. The witness confirms this statement, and that what has been viewed is a snippet of the events, and that the snippets does not reflect the time of the day, and only the duration of the snippets are reflected, which the witness confirmed as correct. The witness confirmed further during cross-examination that he does not know who filmed the footage depicted in the video. It was then put to the witness as follows. Put differently, sir, it is apparent from your testimony that even on the night in question, you were unaware that any firing of any type of toy gun or real gun had taken place that night. Do you agree? The witness replied that that was indeed correct. I should highlight at this point that the witness's evidence in chief was that he in fact saw nothing, but this is not the appropriate time to deal with these facts. The statement continued that was placed to the witness, I quote, and that was so even though you, on your own version, monitored the screens of the footage being videoed by the two cameras belonging to Gear House. And do you agree? The witness confirmed. I would only say the following. I assume that the line of cross-examination here is pertaining to the actual video footage that was viewed at the time in court. And the statement continued that It is not as if you were watching the filming of something and you saw, for example, a terrorist attack or somebody being shot or shot at, that you would react and panic. And the witness agreed to that statement. Further, put to the witness, you went there, you controlled the monitors, and at the end of the night, you were satisfied that nothing untoward, improper, or irregular had happened, which was confirmed by the witness. For all intents and purposes then, sir, it was a perfect celebration, a birthday bash, and everything had run very smoothly, which the witness also agreed to. Whether this amounts to the defense relying on the contents of the videos depicted in court will be discussed at the appropriate time when dealing with the issue regarding footage. The witness continued to say that the above statement placed to him by Advocate Odes, the summary is also applicable in respect of the second video that was viewed. It was in relation to both items of footage that let me rephrase, it was put to the witness that in relation to both items of footage that you had not known of anything untoward. Do you agree? And he confirmed. And I put it to you, and as I put it to you earlier, and I know that I am repeating myself, but it flows from the sequence of the questioning now. Nobody appears startled or scared in any of the video footage that was captured by Dia. Top page 34. Quoted. Do you agree? The witness asked, sorry, please repeat. The statement was repeated, the reply being yeah, comma, I did not notice them. Correct. Then the following statement was placed to the witness, which the court will deal with later. It would appear that that is why you drew the conclusion that there was not a real firearm being shot on the stage with all the people there. Do you agree? And the witness again asked, can you please repeat? I do not get it. It was again repeated, but worded as follows. If somebody on the stage shooting live rounds there would be a risk, do you agree with me? The witness answered correct, meaning had there been live rounds fired, he confirms that that would result in a risk. I quote from page 35 and will try to expedite and read faster. Page 35 quote, so the indication is that a toy firearm and not a real firearm was used. Do you agree? The statement was not answered at that point as the state indicated that proceedings were too fast and it must be slower, and it was then with thanks repeated by Advocate Odes and phrased in the following manner. I will draw a conclusion for you and let you comment. It is therefore apparent from the reaction, from what we see on the video, that it is most probable that a toy firearm was used in both instances. Do you agree with me? The question I have to go and look at the video again and see the expression, I would have answered like you are saying, pertaining to the crowd and witnesses. Whether you would be able to say it was a toy or not, that remained unanswered. The witness was requested by advocate holders at this point to leave the witness box and to come closer to view the footage, and requested the operator of the footage in court to play all three, and then requested that it only be the 2 gearhouse footage clips for the witness to watch, as his questions will pertain to those 2 clips. That indeed happened. The witness viewed the 2 clips and he returned to the witness box and was then told, I quote, you have now had the opportunity to watch the 2 gearhouse videos, and in particular the second one focused on the people on the stage. I want to put it to you that it is obvious that nobody was afraid, startled, or running away. Do you have any comment? The witness now replied to say yes, it is correct. After obtaining instructions from his client, accused 1, advocate holders asked the witness that since he has now watched the videos, whether he is able to identify accused 1 in the respective videos, to which the witness answered no. That concluded cross-examination by advocate holders, and the court will proceed to deal with cross-examination by Advocate Matthews on behalf of accused 2. The witness confirmed that he only saw the second video clip for the first time in court today, and it was put to the witness that therefore, since the footage is taken from an angle, maybe where one of their cameras were, yet there is nothing to say it comes from gearhouse. The witness replied as follows, I was saying the first time, meaning that when the NPA or the Hawks came for the first time, they were taking clips from the video or point of interest. So they showed me that video. The second one, they did not show me at the time. Advocate Matthews asked the witness whether he is saying that the NPA or the Hawks were taking clips, and the witness asked him to repeat this question. The question was indeed repeated, and the witness answered by saying, yes, this is from, it is a clip from the video recorded. Lastly, it was put to the witness that one cannot see accused 2 on either of the clips, and the witness confirmed it as correct. Re-examination by Advocate Sisa. The witness was asked regarding his answer during cross-examination on behalf of accused 1, and that he testified he had lost control of the video after it was set up, and the witness replied by saying he had understood the question to be that he was the one operating the camera, and to that he had replied no, not that he had lost control of the video, as he was not operating the camera. With regards to the footage and questions pertaining to people running, the witness testifies on being asked if in the direction the shots were fired to, or where the person stood, where shots were fired, whether there were people standing there. The witness replied, as page 40 of the record, were there people standing there on the field? The witness replied that yes, indeed, there were people standing on the field, and that the people were standing in the front of the stage. End of questions by court. The court requested the witness to watch the third clip that was played in court. He had confirmed that he is familiar with accused 1, but no one else caught his attention. That was the extent of the questions posed by court. No questions by court on behalf by Advocate Caesar or Advocate Odes. Advocate Matthews at this point stated the following based on the court's questions. Advocate Matthews repeated the evidence of the witness, which he confirmed that the third video clip was not taken by his company, and he can't even say if it was taken on a specific day or not. I think based on the evidence of this witness, it is clear that it was not, and it is so viewed. I'm sorry, I see we are at 20 past 11. I'm going as fast as humanly possible, but I need to at least give some people a 10-minute water break, comfort break, the people who are standing, and then I will return at 11:30. In order. Please be seated. Waiting for everyone to enter, and then once they're seated I can continue straight away. It's just difficult to do so when there's... Okay, put a ruler in so I know where I start. I'm just going to move this microphone. Is it fine, this microphone, if I just move it a little back for working space? Or otherwise my file is not fitting on the bench. Right. On resumption then, judgment continues after the 10-minute adjournment. The court will then proceed and deal with the evidence of Samuel Kwata. Testified he was also employed at Gear's company situated in Durban. On 28 July 2018, he was a senior audiovisual technician. He started working for the company during the year 2007 or prior. He cannot recall the exact year. He confirmed that on 28 July 2018 he was part of the contracted persons to come to East London for work-related matters pertaining to the EFF's 5th birthday anniversary celebrations. His duties were on the said date entailed supervising the technicians and looking after the equipment. The looking after equipment part is a verbatim quote. Since he was a senior technician, he was also one of the persons who installed the video recording cameras. He testified that originally they were to install 3 cameras, but only used 2 cameras as there was already a cameraman on the left-hand side of the stage. So they only used 1 camera for the right upstage or the upstage right of the stage and the front of house, which he explains is next to where their control facility is. Further, that the cameras were about, according to him, 40 to 45 meters, being the one on the left hand and the one in front of house. Just a light, just a little bit. Just a little. Thank you. Sorry. It blinds me when I look up. Now it will go faster. Further, that the cameras... Okay, I stated that. The witness explained that on the said date, as is the norm, they normally conduct formalities at these rallies, being prayers and then the speeches, and also followed by entertainment. Stated that he knows accused number 1 from seeing him on the television, and on questions by the state confirmed that he also saw accused number 2 on the day in question. No, sorry, accused number 1 on the day in question, as he was the person who delivered the speech during the day. The time he cannot recall. He testifies that he did not see accused 2 on the day in question. The duties he performed at the celebration was to take care of the graphics for the back screen on the stage during the proceedings. He testified that he heard there is witnesses regarding the shooting that happened on the day in question. On being asked by the state whether he saw any shooting on the said date, he replied that he heard about it the next day as they were clearing up and packing up their equipment. He continued to say that they were shown on a phone by a guy that worked with them but who was not present at the time, who showed them the clip on his phone and described what he saw was singing and dancing and then the gunshots. Page 7 of this record. He did not see who was shooting, as the video clip did not show who was shooting. He, however, did not hear anything at Sisa Dukashe Stadium on that day or night that sounds like gunshots. Back at their offices in Durban, Sabs visited their office and he was called and told to take the footage from the machine, or to make the footage from the machine, to take the footage from the machine they were using and to put it on their hard drive. He explained that the machine he is referring to is the machine they used on the data of the celebration, called a television studio. It is a converter and it records onto a laptop, and after a show or event they take the footage, being the recording, and load it onto a hard drive, which may also be given to the client or customer. He only recalls one of the specific officials that visited their offices, being Brigadier Govender. He testified that as soon as the event ends, they remove the footage and places it on a hard drive, which is supplied by the company or at times by the client. With regards to this specific event, he recalls that the recording was done and handed to the project manager. He testified that he personally did not tamper with any recording or footage in any manner. Video clips were played that the witness viewed in court and confirmed that the special effects as it appears on the screen are indeed the specific special effects done by himself at the event. He also confirmed that on the date of the incident, the video footage correctly depicts the setup of the stage. However, he does not constantly observe what is happening on stage, as he uses software to play graphics and only uses his eyes to do so, and confirmed that he looks directly at the stage with his own eyes, but however did not see any shooting on the stage at all. He confirms that indeed he saw the dancing and the singing of struggle songs on stage during the event, and it is what he viewed now in court. He also confirmed that the footage indeed what was taken or recorded on the day in question, and that he had downloaded the footage and handed it to Brigadier Govender and his team. The third video clip was also shown to the witness. Let me find it again. And he testified that he has not seen the said footage. It begs the question then as to what was shown to him on a cell phone by a colleague. He also testified he had not seen the third video clip before, and it was the same video I apologize. And it was indeed, no, let me rephrase and try again. It's blind, it's difficult with the glare on the pages. Okay. The third video clip was also shown to the witness, who testified he has not seen the said footage before, and it was not the same video that he was shown by his colleague. The witness confirmed that he was present at the time that the firework display took place. That was his evidence in chief. During cross-examination by Advocate Holders on behalf of accused 1, the witness confirms that he was not the cameraman who recorded the footage on the day in question. It was done by their interns, whose names he cannot recall, and they swap around as it is a tiring job, and he is unable to say who captured the footage. He continued to state that the laptop that was used by Gearhouse on the day of the event in question was later, after an event, when they were checking their equipment at the office. They noticed that one of the laptops are missing, and on checking the serial numbers, they found that it is the laptop that they used to record the EFF's 5th birthday celebration, and that it is missing. And on reporting it to their project manager, Mr. Julian Chetty, they went to the ICC in Durban and was told to report the matter to the police if they want to view the footage as to who and how the laptop was misplaced. In essence, the defense confirmed that the witness personally opened a police docket reporting that the particular laptop was stolen, and it was the same laptop used at the celebrations, which was established by using the serial number of the said laptop. The witness also confirms that he was not made aware of any shooting during the incident or event. Further, that he cannot identify who was shooting in the video clips viewed in court and played by the state. He also did not hear any gunshot sounds during the event. He is also not aware of any damaged equipment after the event or any reports of any injury sustained during the event. With regards to the placing of the cameras, the witness explains that the camera right in front of the stage would be the camera that will be on right hand side of the stage, and therefore they recorded on the right hand side of the stage. He was not involved in the processes involving the provision of the footage to subs, and testified he was just called and told to provide the gentleman with the footage, and he did not speak to him or them. Thereafter, the laptop was then taken by Mr. Singh and placed it where the other hard drives were placed. He is, however, not sure, as he left after the download and sorted out the information and the hard drive devices, which subsequently was stolen. During the event, he confirms he did not focus on the stage as he was ensuring that the graphic side of the event went well. The only sound that he heard was when the fireworks went off, which he saw, as their stage is a dome, so the fireworks were placed, I quote his words, away from it, and apparently, or created the appearance that it was coming up on top of the stage. And he used the phrase, the sky. Thereafter, it was difficult to identify the footage because it was cut due to the long version of the footage, but does not know by whom it was by whom it was cut. The third video, the witness confirmed that he does not know where it comes from or what or who created it. There was no cross-examination on behalf of accused 2 by Advocate Matthews, and by court he testified that he saw the dancing and the singing of the struggle songs but did not watch for a long time, but it was entertainment and therefore he watched at times. Also that there was a lot of activity on the stage. Some people would leave and some would step out of the stage. Questions pursued regarding the footage, which ended up, and I will add, to the defense having instructions to apply for the recusal of myself as the presiding officer in this matter. I'm not going to deal with the application. It was dealt then. The record reflects the reasons for the application not granted is on record. But I need to mention that this is the spot where it took place. That had then, in essence, concluded his evidence, and the court will now proceed with dealing with the evidence of the police officers in this matter. Firstly, that being the evidence of Colonel Nyandlama Mkwali, let me continue. On 28 July 2018, the witness was a member of South African Police Services attached to Mdantsane Visible Police Unit. At the time of the incident, he was the head of the section, but has since retired in 2020. On 4 July 2018, he was appointed as an authorized member of the committee regarding the upcoming EFF 5th year celebrations. His duties entailed calling of a security meeting and all stakeholders, including disaster management. I can't see. I'm sorry. Maybe if you can just, yes, it creates a glare on the page. I'm sorry, and then I'm unable to read. Thank you. It's fine now, I hope. Yeah, it's better. Alright, let me continue from the meeting. Included also mostly from Buffalo City Municipality, members from the bomb squad, public order policing, visible policing, and members of the detective unit, including the representatives from the EFF, at that time led by Mr. Techana, at the meeting, and on the 28th of July 2018 led by Mr. Dlamini. And the purposes of the security meeting was to ensure an incident-free event. The first meeting, all the role players had provided their input. The second meeting was to establish the readiness of all, and the third meeting for all to confirm their state of readiness. He was informed by the stadium manager that no more than 10,000 people will attend. It was also decided that attendees will not be allowed to carry any firearms, sharp weapons, or even bottles. This excluded the protectors of the EFF leadership. The meetings were all conducted at the Sisa Dukashe Stadium, and prior to the event, all was checked and the premises was declared safe. This check was done the morning of the 28th of July 2018, and the witness was present at the time the premises was declared safe. Visible policing unit checked the grounds. There were no reports of any firearms or cartridges after the 7 a.m. check on the morning of 28 July 2018. Sorry for this, it's the only way I'm going to. Alright, I've dealt with. The EFF security was already present when they arrived at plus minus 6:30 a.m. on the said morning. Later, when vendors started to enter, they were all checked by the bomb squad unit, and it was established that no vendor was in possession of any item that may pose a danger for society. The vendors were searched by members of visible policing and including searched by the EFF security members. After they had set up their goods, the gates were opened for the public to start to enter. They had not encountered any problems. Everyone was very disciplined and all role players, including the EFF, were fully cooperating. The president of the EFF delivered a speech for about 1 hour, and then thereafter the artists performed again. At about 6 p.m., fireworks display started behind the podium, and at about 19:30 p.m., he sent members to the podium to ask the EFF security and to inform them that it is getting late and the gates must be closed by 8 p.m. since there was still a group of people around the podium as artists were still performing. They cooperated and a meeting was called, the debriefing meeting, which was conducted at about 20:05 p.m. He had again informed EFF security that the event must now stop as there were still people around the podium and that the lights of the stage will be switched off due to time. No misunderstandings occurred and people were allowed time to leave. He testified that he was the complainant on behalf of the state in this matter. The purpose of opening a docket was to ensure that the incident that occurred was investigated, or I should say the alleged incident that occurred was investigated. He was called by Brigadier Nkoro, Nkoro, on 1 August 2018, who showed them, or the witness, a clip which had gone viral on social media. He testified that on the said clip he saw a white male giving a firearm to Mr. Malema, and when he was in possession of that firearm, he had started to shoot. The shooting was done by Mr. Malema. The court is quoting verbatim from the viva voce evidence of the witness. In order for a proper investigation to follow, a docket had to be opened, and since they only heard the fireworks on the evening in question, a docket was then opened and registered at Mdantsane police station. The docket was handed to Detective Unit and Colonel Swartboy was assigned as the investigating officer of the matter. He confirmed that he communicated with Colonel Swartboy, informing him that an empty cartridge had been picked up at the stadium and that it was the only time he communicated with Colonel Swartboy. The photographs depicting the stage and setup at the stadium was shown to the witness by the state, and he had confirmed that it is indeed a true reflection of the event and the structures and the setup. He testified that the VOC, which is VOC referring to the Venue Operational Center, was a Wendy house that they used and was about 100 to 150 meters away from the podium. He testified that VOC was situated at the west side of the podium, straight opposite the podium. The clip shows the right-hand side of the podium, and in front of the podium it shows people, and on the podium it shows people were not in front of the male but to the left side. The stadium was closed at 9 p.m. and confirms that Mr. Malema arrived, but he does not recall what time, as the security will only notify them if there was a problem on arrival, and none was reported to him. So he knew that it went calmly and peacefully. He saw accused one for the first time when he delivered his speech, and it was about 1 hour, and estimates the time to be plus minus 14 hours, and he was standing in front of the VOC outside. Discussions took place with the EFF security team, and after the second meeting it was decided that the EFF security will regulate and decide as to whom will be responsible for people on and off the stage at any given time. Further, that they were not informed at any of the security meetings that there would be security personnel on stage, and he did not observe any of the close protectors. And it is also standard procedure that if a member of SUPS should see a firearm on any person's waist, he or she must inform VOC immediately. He was not informed about any shooting incident during the event, and also not at the time of the closing meeting, and did not panic when he heard the fireworks, as he was aware before the time, as this was discussed at the security meeting. With regards to the video clip he viewed, he is unable to say how many shots were fired, but it was a rifle. He also confirmed that the fencing around the podium was damaged, since the speaker and the political songs that were being sung caused the people to move closer and excited the crowd. Cross-examination by Advocate Hodes confirms that he was in charge of SAPS on the day of the event and that all major incidents will be reported to him. He also confirms that that the event went well, everyone was disciplined, and that Mr. Dlamini from the EFF fully cooperated with them. The VOC station was plus minus 150 meters away from the podium. He would communicate with Mr. Dlamini if any problem arises or attention is needed, and he would comply, meaning Mr. Dlamini would comply. He confirms he did not see accused one shoot a firearm at the event, and no reports were received the Saturday night of the evening of the event. He was told that a cartridge had been picked up at the stadium and does not know where it came from. Further, that he does not know who filmed the video footage that he viewed, and that to him it appeared to be a real firearm that was used and not a toy gun. Minutes of the meeting that were held was kept and is available if it is needed by the defense. It was, however, not required. He confirms that where he confirmed where it was held and that it is available if needed by the defense. He confirms that the photographs depicts two fences as shown from the left of the camera, but in front it only had a single fence. He was also not shown or informed of any equipment that was damaged during the incident caused by a firearm or any other form of damage. The witness testified that he is able to differentiate between the sound of fireworks and the sound of a firearm fired, but not if the shots are fired at the same time as the fireworks. Then he will not be able to differentiate. It was put to the witness that accused one will deny shooting any real firearm, to which the witness replied that the investigation will show, and if he had not done so, he will not have been in court for this matter. Cross-examination by Advocate Matthews on behalf of accused one. He states that VIP protectors were not present, only visible policing, and he was not aware that 5 protection unit members were present, and if so, he had not received any reports about shots that have been fired. By court, he mentioned that no damages was reported to him, and by question, based on the court's question, the state asked the witness that if such damage incurred, would it have been what was the procedure, and he testified that if any damages were suffered, it would not be reported to SUPS as a rule, since it is not their property and therefore there will be no need for such a report to be made to him. Brings us to the evidence of Captain, which I will refer to Mali Govender, a member of South African Police Services and attached to the Provincial Communication Head Office Eastern Cape as a communication officer as at 31 July 2018 and has subsequently retired during 2021. She testified she was stationed at the Provincial Head Office Communication Office in the Eastern Cape. Part of her duties was being a spokesperson for SAPS in the Eastern Cape. She also constantly liaised with National Office, Head Office of Communications in the Eastern Cape. The witness also dealt with media statements on behalf of SAPS and only worked at the Provincial Head Office as a provincial spokesperson during 2018 and confirmed she was indeed on duty on 31 July 2018 and explained that she received communication from their National Head Office since she formed part of a national WhatsApp group which included National Head Office and communicators from all the various provinces. On the specific date, she received a video clipping and a message attached requesting communicators to inquire as to which province the particular incident depicted in the video clip that occurred. If memory serves her well, it read as follows, I quote, "Colleagues, please check if anyone is aware of an incident that has happened in your province," unquote, and all communicators in the other provinces responded negatively, and there was an indication that the incident that there was celebrations that took place in the Eastern Cape. The communicators in the Eastern Cape confirmed that celebrations took place at Mdantsane, referring to political celebrations at Sisa Dukashe Stadium in Mdantsane. Thereafter, she contacted her colleague who works at the Mdantsane area and electronically forwarded the video clipping to his handset via her cell phone handset as she had received it. She informed him when she forwarded to him it was for further handling, meaning that he needs to investigate further as a communicator and ensure that his superiors are made aware or are aware, and also that feedback is needed to National Head Office, as the initial inquiry was submitted via National Head Office, and thereafter she played no further part in the investigation of this matter. She testified that on the video she saw an individual who had an instrument in his hand and which had fired shots in the air. The said individual, after firing the shots, turned around towards another individual, and he then walked back towards the crowd that he was addressing. She further confirmed that the video received a lot of attention since it projected the image, and I quote the words used, of a huge political figure in our country, and identified the individual to be Mr. Julius Malema, accused 1 before court. Further, in reply to question by Advocate Sisa, she testified that she forwarded the video footage to Captain Muko, and he is the colleague she referred to during the evidence as the communications officer for the Mdantsane cluster. She testified that she did not tamper with the video clipping or footage in any manner whilst it was on her phone's handset. The said footage was shown to the witness in court, and she confirmed that what she is viewing in court is what was received by her on her cell phone handset, and continues to say that in I quote, "This is how I received the video," unquote. I will try and in an attempt to shorten proceedings, highlight the bone of contention raised by Advocate Hodes on behalf of Accused 1 pertaining to the statements by Captain Govender. But to do so, I need to be thorough and all be placed on record. During cross-examination, she confirmed that she held a high position in South African police services and that the reputation of South African police services depends on her truth and integrity, and that it was crucial for her to retain or create a positive image of the South African police services. Further, that the handset she received the video footage on was returned back to SAPS after a certain period of time. She testified that she received the footage from a certain brigadier attached to the national head office, one Brigadier Vish Naidu, if memory serves her well. Since it has been some time since she received the footage, she confirmed that she did not attend the celebration in question and relied on the footage she received on a cell phone handset. She confirmed that after receiving the video clip and message, she deposed of 2 affidavits, which the witness confirmed in court was signed by her freely, voluntarily, and in her sober senses, and the 2 statements were shown to the witness by Advocate Hodes and submitted to court as exhibits, already stated Exhibit K1 and Exhibit K2 respectively. I do not deem it necessary to go through the whole process of authentication. It was done and accepted as such by court. The first statement was made and signed by the witness on 20 September 2018 as per A6 in the docket, and the second affidavit as per A96 of the docket was signed by her on 28 March 2019 in the presence of Colonel Swartboy. In an attempt to curtail the cross-examination, the court will read into record the 2 statements and then deal with the concerns raised by the defense on behalf of Accused 1. Exhibit K1, paragraph 1, contains her personal details, rank and capacity, and which includes her contact cell phone number, which I do not deem necessary to read into record. Paragraph 2, that the facts are indeed true and correct. Then I will focus on paragraph 3, which reads, on 31 July 2018, I received a video clipping on my official handset depicting an individual firing shots from a firearm and later handing the alleged firearm back to another individual during the 5th EFF celebrations held at Sisa Dukashe Stadium, Mdantsane, East London, on 28 July 2018 from the South African Police Services National Head Office, Communication Office. Paragraph 4 basically entails the part of the evidence where all communicators were requested to check whether they had any knowledge of any incident in the province, and after several inquiries it was confirmed that indeed it was held on the date and place mentioned, and she had brought this under the attention of the Cluster Communication Officer Captain Muko for handling. The witness confirmed that the statement is correct and the court does not deem it necessary to deal with requirements as already stated. It is authenticated. The statement was signed at East London on 20 September 2018 at 12 p.m, commissioned by Colonel Rodney Swartboy. Exhibit K2, also authenticated by the defense, and no need to repeat the requirements in law. Paragraph 1 reads the same, depicting a cell phone number, the same as indicated in paragraph 1 of Exhibit K1. Paragraph 2 is also a repeat. Then paragraph 3, I will quote, on 31 July 2018, I received a video clipping to my official handset depicting an individual firing shots from a firearm and later handing the alleged firearm back to another individual during the 5th EFF celebrations held at Sisa Dukashe Stadium, Mdantsane, East London, Eastern Cape, 28 July 2018, from the South African Police Service's National Head Office Communication Officer. Paragraph 4 deals with the requests that were received by all communicators, and since it was then confirmed it took place in the Eastern Cape, I brought this under the attention of the Cluster Commissioner, Captain Muko, for further handling. The video clipping of the individual firing from a firearm and later handling the alleged firearm back to another individual during the celebrations. The said statement was signed by the witness on 28 March 2019 at 15:30 p.m. and commissioned by Colonel Rodney Swartboy. During cross-examination, the witness then proceeded to confirm and reply to all the questions pertaining to the authentication of the statements deposed to by herself, and there is no need to dwell on this aspect. She was referred to paragraph 1 of Exhibit K1, which was read out into the record, and it is noted, and she confirmed that she had provided a cellular phone number in paragraph 1. Paragraph 2 of Exhibit K, also read into the record, including paragraph 3 and 4 of Exhibit K1, which the court placed on record and the witness confirmed as correct during the cross-examination by Advocate Holders pertaining to the contents of the said exhibits. The witness also confirmed that the contents of the exhibit as read into the record covered everything regarding the involvement of the witness in this matter. She confirmed that she also deposed of the second statement and read out into the record and accepted by court as Exhibit K2. In answering as to why she felt the need, and I would highlight this being the bone of contention as far as it pertains to this witness, why she had felt the need to depose of the second statement, the witness explained she wanted to indicate that she had The witness explained she wanted to indicate that she had forwarded a copy of the video clipping at the time when she made the inquiry, and that she forwarded the video clipping to Captain Muko, which she omitted to mention in her first statement, and that she wanted to clarify that she had forwarded it through to him individually as well. Verbatim quoted as per transcribed record, page 35. The explanation was a matter of concern for the defense, as it was put to the witness that her explanation cannot be truthful, since paragraph 4 of her first statement clearly states that she had, I quote, forwarded and brought this under the intention of the Cluster Communications Officer Captain Muko for further handling, and therefore it stands to reason that it was already mentioned in Exhibit K1. The witness explained that there is a difference between the two statements in as far as she did bring it under the attention, and the second time she forwarded the video clipping that she had received directly to Captain Muko at his request. That is why she made the second statement, therefore adding she had forwarded the clip at the request. It was put to the witness that paragraph 1, 2, 3, and 4 reads the same as already stated, and on being, including that of Exhibit K2, and on being asked to confirm that it reads the same, the witness replied, and I quote verbatim from the record, page 36, the video clipping of the individual firing shots from a firearm and later handing the alleged firearm back to another individual during the 5th EFF celebrations held at Sisa Dukashe, Mdantsane, on that date was forwarded to Captain Mzuko, mentioned, and that did not form part of the initial paragraph of the first statement. On further pursuing this issue, the witness states that there is a difference between the two statements, as the first statement does not mention, I quote, the video clipping of the individual up until mentioned at the end. The last sentence on paragraph 4 is not included in paragraph 4 of the first statement. In essence, it was confirmation of what was placed before the witness by the defense. Further, that the following was added in the statement: the video clippings of the individual firing shots from a firearm and later handing the alleged firearm back to another individual during the 5th EFF celebrations held at Sisa Dukashe Stadium, Mdantsane, East London, on the said date, was forwarded to Captain Mzuko, which the witness confirmed as correct. In this regard, it was pointed out that the video does not depict any firearm being handed over and back to anyone else, and the witness explained that when she viewed the video, she did not investigate the matter. She merely made or deposed of her statement, as she had seen an individual firing shots, turning around, facing another individual and walking back, facing a crowd now without a firearm. And therefore she concedes she assumed that the said individual might have handed the particular firearm to another individual, and states she did not see it. That is what she assumes. With regards to the reference to, I quote, an alleged firearm, as to why she used the terminology of alleged firearm, she explained that she cannot make a factual reference to something which she had not physically seen. She only witnessed it on a screen, and further that it appears to be a firearm, it sounds like a firearm, but she cannot make a factual finding, and that is indeed her assumption as to what she viewed on the video clip, that an individual fired shots from an alleged firearm. The individual turned around, faced another, walked back without anything in his hand, so that is how I made that assumption. Verbatim, page 39 of the record. It remains to be an assumption, as it is not seen by the witness. The witness confirmed that her cellular phone was not taken by subs for analysis at any time since the incident. Cross-examination continued on the same principle pertaining to the second statement as the first statement, regarding her assumption of handing the alleged firearm back, and confirms that it remains her assumption even with regards to her second statement. It was also put to the witness that she did not on her own accord decide to clarify her statement, but she was requested by Colonel Swartboy to do so, since it was made about 6 months after her first statement. The witness clearly explained that she was not requested by Colonel Swartboy to depose of the second statement. She was approached and asked at that stage by Colonel Swartboy whether she was happy with the statement she had made on the very first day she became aware of the video clip, so her first statement, and then only she had insight or viewed the statement, and on perusing the statement she wanted to clarify that she had forwarded the particular video clip to Captain Mzuko. This, however, was not acceptable to the defense, and on further questioning, the witness explains that Colonel Swartboy was busy with the investigation of the matter, and when he approached her to ask whether she was satisfied with the statement she deposed of, she stated or informed him she wanted to clarify this aspect, that she forwarded the particular video clip to Captain Mzuko. It should be kept in mind or borne in mind that from the day she deposed of her first statement up until she was approached to confirm whether she is happy with her first statement, she had no further involvement in this matter at all. She continued with her day-to-day daily tasks. She had complied with the request she had received. Okay. The reason as to why she did not add The reason as to why she did not add that she did not see a firearm being handed from one person to another, in her second statement she explained that she did not pay a lot of attention to the video clipping. She watched it briefly, and with that in mind she drafted her affidavit, and it was written by her, and also that she had no reason to continue watching the video clip as she had watched it, forwarded and deposed of her affidavit, and that it concluded her part in the matter. And all she needed to do was to forward the information to someone to have it investigated further, and that she had done so. She did not investigate the details of the case, and one may say moved on with her daily activities as usual, and did not spend any more or further time dealing with the matter. On further questioning, she replied that she felt it was a crucial point in the matter that she clarifies that she indeed forwarded the particular video clip to Captain Muko and therefore included it in her second statement. That was the bone of contention regarding the evidence of Captain Govender. There was no cross-examination by Advocate Matthews and no re-examination by the state concluded the evidence of Captain Govender. The court will now deal with the evidence of Captain, I think now Colonel Nkosiko Vincent Mzuko. He testified that on 1 August 2018, he was a captain in the South African Police Services attached to the Mdantsane Police Station, East London, in the capacity as a cluster communications officer, and currently holds the rank of Lieutenant Colonel. He has 15 years' experience as a communication officer at SAPS. The duties involve the monitoring of and answering queries or inquiries from the media. He also confirmed that he was on duty on 1 August 2018. On the above-mentioned date, he testified that he received a video clip from Captain Govender, who also works at the media center at the provincial offices situated in Zwelitsha. He testified that the video he received was trending on social media, and the inquiry was with regards to if there were or there was indeed an event of this nature that occurred at Mdantsane. The witness testified that he confirmed that indeed there was an event of this nature that occurred in the Mdantsane area. He testified that the video depicted Mr. Malema as well as Mr. Snyman, and in the video Mr. Malema was shooting a firearm upwards. He continued to testify that in the same video Mr. Malema handed over the firearm to Mr. Snyman, and that is where the video ended. The video was sent to him by Captain Govender via a state-used cell phone, meaning she sent it from a cellular phone to his cell phone. The first instruction from Captain Govender was to confirm the event which he had done, and secondly, to ensure that it is reported or brought to the attention of his commander, and thirdly, he forwarded the video to the phone of Colonel Swartboy, who was the commander at the detective unit at Mdantsane. He forwarded the footage via the WhatsApp method. He further reported the matter to Brigadier and Corporal. With the above He did not forward the video clip or WhatsApp to Brigadier Nkopo. He, however, in person showed him the video clip. Thereafter, as management, they all sat down together and the decision was made that it must be investigated, that an inquiry should be held with regards to the incident, and therefore a docket is still required to be opened when reference is made to an inquiry. In the matter before the court, it was opened under Mdantsane Case 06-08-2018. At the time he was requested by Captain Govender regarding the events, he confirmed that he had indeed had personal knowledge of the event that was to be held on the 28th of July 2018 by the EFF, being the 5th birthday celebration. He knew this as he had also viewed it on television. At this point, the footage now known to be video clip 3, or as referred to as the viral footage, was shown to the witness, who exited the witness box to enable him to view the footage played in court. After viewing the footage, the witness confirmed that it is indeed the footage that he viewed and received on his phone sent to him by Captain Govender. In his view, the firearm depicted in the footage appears to be a rifle. He ended his evidence in chief by saying he had handed the video to Colonel Swartboy, who is the investigating officer of this matter and will bring more clarity. I need to add that at this stage, we will embark on quite a lengthy cross-examination that occurred. Just a moment. Therefore, cross-examination by Advocate Holders on behalf of Accused 1 confirmed that he no longer has the cell phone in his possession that he used on the said date, as he no longer works there, meaning at Mdantsane, and confirmed that it is the same phone he used to forward the footage or the video to Colonel Swartboy. He has left Mdantsane but still within the SAPS, and however he is now based in Pretoria. He also confirmed that he was the communication officer for Mdantsane on the 28th of July 2018. However, he had not taken any action as he only received the inquiry on 1 August 2018, on which date he indeed acted on the information. In essence, that paragraph summarizes lengthy cross-examination pertaining to the fact that since 28 July up to 1 August, he had not taken any action regarding the alleged incident. It was asked or placed before the witness that he was not the first police official to not have taken any action during the month of July regarding this incident. The witness was reluctant to reply on behalf of all other officials, but confirmed that he took action only after receiving the video clip on 1 August 2018 with regards to his scope of duties as the communication officer. As to whether there was an entry at the Mdantsane police station prior to 1 August 2018, which was also a bone of contention by the defense, the witness states that he did not want to comment on this, since he maintains that will or is not known to him. Although the case number is indeed 0608-2018, he cannot commit to say if any entries were made by any other officials regarding the incidents in any of the registers held at Mdantsane police station. He confirmed that thereafter he did not play any further role in this matter, as he is not an investigating officer but a communication officer, and that with certainty he is able to say that his only role was to receive the footage and to forward the footage.
The witness confirmed that he deposed of a statement and fully appreciates the procedure as far as it pertains to the truthfulness of the statement and the consequences of taking the oath. It needs no further discussion. A statement was then handed to the witness, as well as the court, being a statement deposed by the witness. Again, he confirmed indeed it to be his statement and signature. The contents of the statement was then read out step by step to the witness, who confirmed paragraph 1, where he identified himself, his rank and contact numbers. Paragraph 3 was deemed important by the defense and read out. Therefore, for record purposes, the court will repeat the content as read. On 1 August 2018, I received a video clipping to my official handset depicting an individual firing shots from a firearm and later handing the alleged firearm back to another individual during the 5th EFF celebrations held at Sisa Dukashe Stadium, Mdantsane, East London, CAS 06/08/2018, from Captain Marley Govender of the Sept Provincial Head Office Communication Office, Eastern Cape. He was asked to confirm if that paragraph is correct, which he indeed confirmed as correct. He was then requested to confirm if there was indeed an event held on the mentioned date and to bring under the attention of the station commander, of which he did, and he had confirmed that statement placed before him as correct, and that the oath was taken on 7 August 2018 at 15:20 p.m. and that it was taken by Colonel Swartboy. It was then put to the witness that the statement does not state that he had sent the footage to the investigating officer, Colonel Swartboy. The witness confirmed that there is no mention of Colonel Swartboy in his A7 statement. The question is as to why it is not entailed in the statement. The witness explained that he was following the instructions he received and acting on the requests that were made by Captain Govender, which are the specific aspects that are covered in his statement and what was needed for the statement. Further, that it may have been a mistake not to add it in his statement, but he knew that he would be called to testify in court and will then testify regarding the aspect of his evidence. It was also not pointed out to him by Colonel Swartboy at the time he made the statement. The witness confirmed that in his statement he refers to an individual and does not mention any specific person. The reason as to why he did not mention any individual is because he knew he had to wait for a facial identification expert, and during the time of making the first statement he had not yet received the said information. He, however, confirms that he knew who the people in the clip depicted, the clip that was viewed by him, but he had to be professional and wait for the report. Therefore, he agreed to the submission by the defense that it was, in his view, fair at that point not to mention a person but to refer to an individual. On being asked what he meant when saying handing the firearm back, the witness explained in this case it is to give a person a firearm. The person took it and left with it. It was then put to the witness then, and the court will again quote verbatim, "I disagree with you, sir. There is no reason to make this a special case. I only hand something back if I have received it from somebody. Do you agree?" The witness replied, "It is fine if that is the defense's opinion and may disagree with him, since he stated it the way he saw it and the defense might see it in a different way." Advocate Hodes placed it before the witness that he still disagrees and that he will show him why, and requested the witness to watch the video, being video footage clip 3. The witness viewed the footage and was informed he may return to the witness box, as he had now watched the footage and has not requested anyone to stop the footage during the time he viewed the clip. It was then put to the witness as follows. So do you agree that there is no handing over of a firearm on the video? The witness did not agree with that submission or statement. He was asked, if that is so, why did he not stop the video to show everyone that what he is seeing? The witness explained that he was watching the video closely and carefully in an attempt to see if he sees what the defense is referring to, and he does not see what they are seeing. It followed by the statement, so you did not see a handover of the firearm on the video. Do you agree? The witness did not agree with this statement. The video was then played for the witness to view again, with the request to show the defense where it shows that a firearm was handed over. The video was played and it was put to the witness by Advocate Hodes. He is now challenged to show the handing back of the alleged firearm. The witness viewed it and stopped the footage, saying, "Stop, that is where it happened," unquote. After this exercise and the replay by the witness, it was put to him that there is no handing over on the screen in the video that you have shown whatsoever. Do you have any comment? And the witness complied that he still maintains that there is a handing over. It was then put to the witness, I quote, "Show me the firearm, sir," at the spot where the video clipping was stopped. You cannot even see a firearm. The witness replied saying, as we all see it, that he was carrying a firearm and Mr. Snyman came nearer to take the firearm. That is where they exchanged. They exchanged the firearm, and if you look clearly, after a second, Mr. Malema was no longer carrying a firearm. It was again put to the witness, so, you do not see a handover, correct? The witness disagreed once again with the statement put to him. It was further put to the witness that you do not even see a firearm being exchanged from hand to hand. And the witness disagreed with that statement as well. The dynamics of cross-examination now changed, and this is an important portion of the cross-examination. And it was put to the witness then, it is because he is not telling the truth, as all who is watching this video and we do not see it, and there is not a point that you can show me the firearm going from one hand to another. The witness replied that indeed what he is saying is the truth. Firstly, and I quote, "Let us look what happens with regards to Mr. Malema, what he has in his hand, and then thereafter look at them when they are meeting up there. As they are meeting, and look after them meeting up, then there what happened, because you can see that indeed they are exchanging a firearm." This was not welcomed by the defense, and Advocate Hodes put it to the witness that you do not, sir. The item could easily have been put down, put on a table, given to anybody else. You do not see it go from, as you call it, Mr. Malema to Mr. Snyman on any video that you have been shown in this court. The witness disagreed with the above statement put to him. He also confirms that he has not been shown any other video clippings, and whatever he had read about the incident at the time, he no longer has. This comes from a question based on if he had read any articles or reports on about the incident. And it was then put to the witness that all these documents was discarded by the witness. The witness replied, indeed it was not discarded by him. He merely left it at Mdantsane when he was appointed or moved to Pretoria. Dealing with the viewed footage, it was put to the witness that he cannot tell what type of rifle it is, and that is why he only stated it looks like a rifle. The witness replied that that is good to say that it looks like a rifle, however, he cannot say what model rifle it is. Therefore, it was put to the witness, he cannot then dispute that it was indeed a stage or a TV gun. The witness stated that firstly, that he did not understand the question and it is to be repeated, which was kindly done. That it may also be a TV gun, to which the witness replied that to him it appeared to be a rifle. The witness was shown a statement marked as A94 in the docket. The normal questions pertaining to authenticity was asked and confirmed by the witness. There is no need to repeat the procedure, and further that it was dated and signed on 17 March 2018 at 11:35 a.m. at Mdantsane. Here I need sure I brought one, thank you. Sorry, I just want to... After the video, the witness confirmed the authenticity of the statement marked as A94 in the docket, and I've already placed the date and time on record. It was put to the witness that based on the above, as the statement was read out, it was put to the witness that now it is another untruth being told, when he testified he had only made one statement. The witness replied he answered one as far as it pertained to the question he was asked about the video footage. Again, the witness was told he is now telling another untruth, and he replied to his understanding he was responding to the question regarding his statement with regards to the video footage, and the statement now shown to him does not refer to the footage. It was put to the witness that his understanding of the questions is false, and that the record will reflect it, and if he wishes to apologize at this point, he may do so. And the witness replied that in all honesty, he thought that the question he was answering to was regarding the video footage and nothing else. Based on the answer provided by the witness, the defense deemed it necessary to put to the witness, right, so you're standing with a lie. You are not apologizing. Is that correct? To this, the witness replied that to him it is not a lie, it is the truth. They had then proceeded to the contents of paragraph 3 as to establish the truth of the witness. And I need to read out the said paragraph into record. I was requested by the investigating officer, Colonel Swartboy, to compile a report from different media houses that covered the alleged incident where shots were fired, allegedly during the 5th EFF celebrations held at the Sisa Dukashe Stadium, Mdantsane, East London, Eastern Cape, 28 July 2018. I made copies of the different media reports that covered the mentioned incident and compiled a report as requested on 31 August 2018. The witness confirmed that indeed the contents or the statement is correct, and this was followed by the following statement put to the witness, that he had earlier testified to the effect that he had played no other role besides the receipt and the transmission of the video. So to this, the witness testified at that point he was answering to the role with regards to the video footage and not to any other role. This led to the defense putting to the witness that it is becoming worse and worse. The witness emphasized that he understood the question to be whether he had played any role with regards to the video. Therefore, he had replied no. The witness was asked what he had done with the media clippings he had left behind, which the witness then asked if he recalled the question, confirmed as correct, since he indeed left it behind as he no longer works at Mdantsane. And on being confronted about not mentioning that he compiled a report pertaining to the media clippings, he merely answered that he had not been asked, and further what there is to mention in the statement that it had been discussed in court about compiling an album as he compiled a report. He had not been asked, according to the witness. He then proceeded to confirm that indeed he did not mention that he compiled a report as he answers to what he is asked. He also deems it necessary in court to answer what is asked in court. It was then pursued and put to the witness, in this regard then, you are not prepared to say you made a mistake earlier. You are not sorry. You are sticking with your earlier answers. Is that correct? The witness replied clearly that his answers stand because indeed they have reasons to stand. It was put to the witness that the defense does not have a copy of the report, and this is not known to the witness, and he replied that he handed it to Colonel Swartboy. He, however, cannot recall the specific data he had handed to him, but recalls he did hand it to him. I should add that this report never formed part of any of the exhibits that was presented by court. It was the first mention of it. The defense now referred the witness to the third statement as per A95 in the docket. The process of authenticating the statement has been followed and does not need to be repeated. And the said statement it was then highlighted that the said statement, when compared to the statement marked A7, paragraph 1, 2, 3, and 4 read identical, which the witness confirmed. At this point, the defense had requested that the statements be submitted of the particular witness, and it was marked individually or respectively by court as exhibits G1, G2, and G3. This was done by the consent of the state and the defense for accused 2. At that point, the matter was adjourned, and after some time, on resumption of the matter, Advocate Holders continued with cross-examination, and he confirmed that on the last appearance he testified that the firearm he saw in the video looks like a rifle. However, confirms he cannot identify the make or the caliber or the type of ammunition that it may fire, or whether it was live or blank ammunition that was fired. Further, that he cannot say that it was a blank firearm or not, but it did fire a shot. He also cannot say it was not a TV or blank firearm, but to him it still fired a shot. It continued and was put to the witness. He also cannot say whether it was a, don't know if I made a typing error, PAK, meaning pistol automatic knal, correct? The answer remained the same. He cannot, but it did fire a shot. You also cannot tell this court whether that firearm had been modified in any way, to which the witness agreed. I cannot. But I remain to say that this firearm shot a shot. The witness confirmed that he had not been informed that any damage was reported, what was incurred in the area of the alleged incident, as a result, a projectile emanating from that firearm. I just want to double check, because memory serves me well. During cross-examination by Advocate Holders, there was a portion after dealing with the first statement where he was asked if he is sure that he had at no stage deposed of any further statements, and that emanated from memory on the statement made to the witness. Did you not at any time decide to make a further statement to see, which refers to, we have a problem here, we need to fix it? And based on that statement, the witness replied no. And that explains now his explanation as to why he said no, but confirms making statement 2 and 3. That is highlighted and is in my memory now. Cross-examination by Advocate Matthews on behalf of accused 2. It was put to the witness that the facial identification expert was unable to come to a conclusion that the individual in the footage is indeed accused 2, and therefore the reasons he provided for referring to accused 2 as an individual is an untruth, and that the video does not depict accused 2 handing a firearm to any person. The witness replied that he hears the question, and he had testified that he said in the video he viewed it was accused 1 who handed a firearm to accused 2. That finalized the evidence of Captain Muko. Just give me a minute if I do whether I'm going to deal with the IO or. Yes, at this point, the court is of the view that it is an opportune time now to first deal with the evidence of Colonel Swartboy, as his evidence is not specific as to serial numbers, exhibit numbers, but he gives an overall reflection of the investigation. Therefore, I deem it necessary to deal with his investigation first, followed by the process followed thereafter, meaning the handling of the exhibits, seal numbers, etc. Now at this point it is 1 o'clock. I know I've indicated, and I'm saying it on record for all because it's been sent to all. I anticipated that we may, I hope we do not run out of court time. I sincerely do. And the request was that the court should consider allowing the media to set up early enough so that we can start at 9, which happened. Thank you very much. And secondly, that we curtail tea adjournments, which we did. It was a 10-minute tea adjournment. The second request was not to adjourn for lunch at all and to work until late tonight. So that part of working late tonight, I cannot answer. It will have to be taken up by whoever is present in court and can deal with that part of the protocol at the office. With regards to shortening the lunch adjournment, I have no problem with that, but I will still ask the input of all others, as I have a duty to do so.
Half an hour adjournment.
That's your view, ne?
Yes.
So noted. Advocate Odes?
I'll take the same view. I need to report you so that we did, speaking for myself, I've cleared my diary for tomorrow as well. I don't know what the position of my administration.
Okay. I will by all means try. It is, yes, I thank you. So you also only require 30 minutes.
Yes,
Your client as well.
yes, yes.
Advocate Matthews, please say you require an hour. Now no one understood you in the entire country, so you want 30 minutes.
30 minutes.
Is it sufficient? Yes, as I say, wait.
Also, it's because tomorrow we have cleared out.
Oh, as well, thank you. I didn't receive any response from the state pertaining to the email I sent on Friday. Okay. I think you also, I copied you in it, but in essence, it was an indication that in anticipation of a possibility that the matter is not finalized, is there a possibility that it can be rolled over if we require a further hour or two to finalize it? And now the defense has confirmed, and as I say, I have not heard from you in that regard.
I've got no issues, Your Worship. I will comply with whatever.
Okay. May I then, in the interim, during the adjournment, ask if there's anyone present in court who can assist with the protocol if we decide, or if it's practical, because it will involve everyone in the building to go over court time. But from my side, I'm willing. So, all right, it's the they set the clock ahead, or they're always. It's 2 minutes past, so we'll come back at 12:35. Huh? Oh, okay, I've been back at 12:45. I will return at 13:45. 13:35. informed him when she forwarded to him it was for further handling, meaning that he needs to investigate further as a communicator and ensure that his superiors are made aware or are aware, and also that feedback is needed to National Head Office, as the initial inquiry was submitted via National Head Office, and thereafter she played no further part in the investigation of this matter. She testified that on the video she saw an individual who had an instrument in his hand and which had fired shots in the air. The said individual, after firing the shots, turned around towards another individual, and he then walked back towards the crowd that he was addressing. She further confirmed that the video received a lot of attention since it projected the image, and I quote the words used, of a huge political figure in our country, and identified the individual to be Mr. Julius Malema, accused 1 before court. Further, in reply to question by Advocate Caesar, she testified that she forwarded the video footage to Captain Muko, and he is the colleague she referred to during the evidence as the communications officer for the Mdantsane cluster. She testified that she did not tamper with the video clipping or footage in any manner whilst it was on her phone's handset. The said footage was shown to the witness in court, and she confirmed that what she is viewing in court is what was received by her on her cell phone handset, and continues to say that in I quote, "This is how I received the video," unquote. I will deal with, try and, in an attempt to shorten proceedings, highlight the bone of contention raised by Advocate Hodes on behalf of accused 1 pertaining to the statements by Captain Govender. But to do so, I need to be thorough and all be placed on record. During cross-examination, she confirmed that she held a high position in South African police services and that the reputation of South African police services depends on her truth and integrity, and that it was crucial for her to retain or create a positive image of the South African police services. Further, that the handset she received the video footage on was returned back to subs after a certain period of time. She testified that she received the footage from a certain brigadier attached to the National Head Office, one Brigadier Vish Naidu, if memory serves her well. Since it has been some time since she received the footage, she confirmed that she did not attend the celebration in question and relied on the footage she received on a cell phone handset. She confirmed that after receiving the video clip and message, she deposed of 2 affidavits, which the witness confirmed in court was signed by her freely, voluntary, and in her sober senses, and the 2 statements were shown to the witness by Advocate Hodes and submitted to court as exhibits, already stated Exhibit K1 and Exhibit K2 respectively. I do not deem it necessary to go through the whole process of authentication. It was done and accepted as such by court. The first statement was made and signed by the witness on 20 September 2018 as per A6 in the docket, and the second affidavit as per A96 of the docket was signed by her on 28 March 2019 in the presence of Colonel Swartboy. In an attempt to curtail the cross-examination, the court will read into record the 2 statements and then deal with the concerns raised by the defense on behalf of accused 1. Exhibit K1, paragraph 1, contains her personal details, rank and capacity, and which includes her contact cell phone number, which I do not deem necessary to read into record. Paragraph 2, that the facts are indeed true and correct. Then I will focus on paragraph 3, which reads, on 31 July 2018, I received a video clipping on my official handset depicting an individual firing shots from a firearm and later handing the alleged firearm back to another individual during the 5th EFF celebrations held at Sisa Dukashe Stadium, Mdantsane, East London, on 28 July 2018 from the South African Police Services National Head Office Communication Office. Paragraph 4 basically entails the part of the evidence where all communicators were requested to check whether they had any knowledge of any incident in the province, and after several inquiries it was confirmed that indeed it was held on the date and place mentioned, and she had brought this under the attention of the Cluster Communication Officer, Captain Muko, for handling. The witness confirmed that the statement is correct and the court does not deem it necessary to deal with requirements as already stated. It is authenticated. The statement was signed at East London on 20 September 2018 at 12 p.m., commissioned by Colonel Rodney Swartboy. Exhibit K2, also authenticated by the defense, and no need to repeat the requirements in law. Paragraph 1 reads the same, depicting a cell phone number, the same as indicated in paragraph 1 of Exhibit K1. Paragraph 2 is also a repeat. Then paragraph 3, I will quote, on 31 July 2018, I received a video clipping to my official handset depicting an individual firing shots from a firearm and later handing the alleged firearm back to another individual during the 5th EFF celebrations held at Sisa Dukashe Stadium, Mdantsane, East London, Eastern Cape, 28 July 2018, from the South African Police Services National Head Office Communication Officer. Paragraph 4 deals with the requests that were received by all communicators, and since it was then confirmed it took place in the Eastern Cape, I brought this under the attention of the Cluster Commissioner, Captain Muko, for further handling. The video clipping of the individual firing from a firearm and later handling the alleged firearm back to another individual during the celebrations. The said statement was signed by the witness on 28 March 2019 at 15:30 p.m. and commissioned by Colonel Rodney Swartboy. During cross-examination, the witness then proceeded to confirm and reply to all the questions pertaining to the authentication of the statements deposed to by herself, and there is no need to dwell on this aspect. She was referred to paragraph 1 of Exhibit K1, which was read out into the record, and it is noted, and she confirmed that she had provided a cellular phone number in paragraph 1. Paragraph 2 of Exhibit K, also read into the record, including paragraph 3 and 4 of Exhibit K1, which the court placed on record and the witness confirmed as correct during the cross-examination by Advocate Holders pertaining to the contents of the said exhibits. The witness also confirmed that the contents of the exhibit as read into the record covered everything regarding the involvement of the witness in this matter. She confirmed that she also deposed of the second statement and read out into the record and accepted by court as Exhibit K2. In answering as to why she felt the need, and I would highlight this being the bone of contention as far as it pertains to this witness, why she had felt the need to depose of the second statement, the witness explained she wanted to indicate that she had The witness explained she wanted to indicate that she had forwarded a copy of the video clipping at the time when she made the inquiry, and that she forwarded the video clipping to Captain Mzuko, which she omitted to mention in her first statement, and that she wanted to clarify that she had forwarded it through to him individually as well. Verbatim quoted as per transcribed record, page 35. The explanation was a matter of concern for the defense. It was put to the witness that her explanation cannot be truthful, since paragraph 4 of her first statement clearly states that she had, I quote, forwarded and brought this under the intention of the Cluster Communications Officer Captain Mzuko for further handling, and therefore it stands to reason that it was already mentioned in Exhibit K1. The witness explained that there is a difference between the two statements, in as far as she did bring it under the attention, and the second time she forwarded the video clipping that she had received directly to Captain Mzuko at his request. That is why she made the second statement, therefore adding she had forwarded the clip at the request. It was put to the witness that paragraph 1, 2, 3, and 4 reads the same as already stated, and on being, including that of Exhibit K2, and on being asked to confirm that it reads the same, the witness replied, and I quote verbatim from the record, page 36, the video clipping of the individual firing shots from a firearm and later handing the alleged firearm back to another individual during the 5th EFF celebrations held at Sisa Dukashe Mdantsane on that date was forwarded to Captain Mzuko, mentioned, and that did not form part of the initial paragraph of the first statement. On further pursuing this issue, the witness states that there is a difference between the two statements, as the first statement does not mention, I quote, the video clipping of the individual up until mentioned at the end. The last sentence on paragraph 4 is not included in paragraph 4 of the first statement. In essence, it was confirmation of what was placed before the witness by the defense. Further, that the following was added in the statement: the video clippings of the individual firing shots from a firearm and later handing the alleged firearm back to another individual during the 5th EFF celebrations held at Sisa Dukashe Stadium, Mdantsane, East London, on the said date, was forwarded to Captain Mzuko, which the witness confirmed as correct. In this regard, it was pointed out that the video does not depict any firearm being handed over and back to anyone else, and the witness explained that when she viewed the video, she did not investigate the matter. She merely made or deposed of her statement, as she had seen an individual firing shots, turning around, facing another individual and walking back, facing a crowd now without a firearm. And therefore she concedes she assumed that the said individual might have handed the particular firearm to another individual, and states she did not see it. That is what she assumes. With regards to the reference to, I quote, an alleged firearm, as to why she used the terminology of alleged firearm, she explained that she cannot make a factual reference to something which she had not physically seen. She only witnessed it on a screen, and further that it appears to be a firearm, it sounds like a firearm, but she cannot make a factual finding, and that is indeed her assumption as to what she viewed on the video clip, that an individual fired shots from an alleged firearm. The individual turned around, faced another, walked back without anything in his hand, so that is how I made that assumption. Verbatim, page 39 of the record. It remains to be an assumption, as it is not seen by the witness. The witness confirmed that her cellular phone was not taken by subs for analysis at any time since the incident. Cross-examination continued on the same principle pertaining to the second statement as the first statement regarding her assumption of handing the alleged firearm back, and confirms that it remains her assumption even with regards to her second statement. It was also put to the witness that she did not on her own accord decide to clarify her statement, but she was requested by Colonel Swartboy to do so, since it was made about 6 months after her first statement. The witness clearly explained that she was not requested by Colonel Swartboy to depose of the second statement. She was approached and asked at that stage by Colonel Swartboy whether she was happy with the statement she had made on the very first day she became aware of the video clip, so her first statement, and then only she had insight or viewed the statement, and on perusing the statement she wanted to clarify that she had forwarded the particular video clip to Captain Muko. This, however, was not acceptable to the defense, and on further questioning, the witness explains that Colonel Swartboy was busy with the investigation of the matter, and when he approached her to ask whether she was satisfied with the statement she deposed of, she stated or informed him she wanted to clarify this aspect, that she forwarded the particular video clip to Captain Muko. It should be kept in mind or borne in mind that from the day she deposed of her first statement up until she was approached to confirm whether she is happy with her first statement, she had no further involvement in this matter at all. She continued with her day-to-day daily tasks. She had complied with the request she had received. Okay. The reason as to why she did not add The reason as to why she did not add that she did not see a firearm being handed from one person to another, in her second statement she explained that she did not pay a lot of attention to the video clipping. She watched it briefly, and with that in mind she drafted her affidavit, and it was written by her, and also that she had no reason to continue watching the video clip as she had watched it, forwarded and deposed of her affidavit, and that it concluded her part in the matter, and all she needed to do was to forward the information to someone to have it investigated further, and that she had done so. She did not investigate the details of the case, and one may say moved on with her daily activities as usual, and did not spend any more or further time dealing with the matter. On further questioning, she replied that she felt it was a crucial point in the matter that she clarifies that she indeed forwarded the particular video clip to Captain Muko and therefore included it in her second statement. That was the bone of contention regarding the evidence of Captain Govender. There was no cross-examination by Advocate Matthews and no re-examination by the state concluded the evidence of Captain Govender. The court will now deal with the evidence of Captain, I think now Colonel Nkosiko Vincent Mzuko. He testified that on 1 August 2018, he was a captain in the South African Police Services attached to the Mdantsane Police Station, East London, in the capacity as a cluster communications officer, and currently holds the rank of Lieutenant Colonel. He has 15 years experience as a communication officer at SAPS. The duties involve the monitoring of and answering queries or inquiries from the media. He also confirmed that he was on duty on 1 August 2018. on the above-mentioned date, he testified that he received a video clip from Captain Govender, who also works at the media center at the provincial offices situated in Zwelitsha. He testified that the video he received was trending on social media, and the inquiry was with regards to if there were or there was indeed an event of this nature that occurred at Mdantsane. The witness testified that he confirmed that indeed there was an event of this nature that occurred in the Mdantsane area. He testified that the video depicted Mr. Malema as well as Mr. Snyman, and in the video Mr. Malema was shooting a firearm upwards. He continued to testify that in the same video Mr. Malema handed over the firearm to Mr. Snyman, and that is where the video ended. The video was sent to him by Captain Govender via a state-used cell phone, meaning she sent it from a cellular phone to his cell phone. The first instruction from Captain Govender was to confirm the event which he had done, and secondly, to ensure that it is reported or brought to the attention of his commander, and thirdly, he forwarded the video to the phone of Colonel Swartboy, who was the commander at the detective unit at Mdantsane. He forwarded the footage via the WhatsApp method. He further reported the matter to Brigadier and Corporal with the above He did not forward the video clip or WhatsApp to Brigadier Nkopo. He, however, in person showed him the video clip. Thereafter, as management, they all sat down together and the decision was made that it must be investigated, that an inquiry should be held with regards to the incident, and therefore a docket is still required to be opened when reference is made to an inquiry. In the matter before the court, it was opened under Mdantsane Cas 06-08-2018. At the time he was requested by Captain Govender regarding the events, he confirmed that he had indeed had personal knowledge of the event that was to be held on the 28th of July 2018 by the EFF, being the 5th birthday celebration. He knew this as he had also viewed it on television. At this point, the footage now known to be video clip 3, or as referred to as the viral footage, was shown to the witness, who exited the witness box to enable him to view the footage played in court. After viewing the footage, the witness confirmed that it is indeed the footage that he viewed and received on his phone sent to him by Captain Govender. In his view, the firearm depicted in the footage appears to be a rifle. He ended his evidence-in-chief by saying he had handed the video to Colonel Swartboy, who is the investigating officer of this matter and will bring more clarity. I need to add that at this stage, we will embark on quite a lengthy cross-examination that occurred. Just a moment. Therefore, cross-examination by Advocate Holders on behalf of Accused 1 confirmed that he no longer has the cell phone in his possession that he used on the said date, as he no longer works there, meaning at Mdantsane, and confirmed that it is the same phone he used to forward the footage or the video to Colonel Swartboy. He has left Mdantsane but still within the Septs, and however he is now based in Pretoria. He also confirmed that he was the communication officer for Mdantsane on the 28th of July 2018. However, he had not taken any action as he only received the inquiry on 1 August 2018, on which date he indeed acted on the information. In essence, that paragraph summarizes lengthy cross-examination pertaining to the fact that since 28 July up to 1 August, he had not taken any action regarding the alleged incident. It was asked or placed before the witness that he was not the first police official to not have taken any action during the month of July regarding this incident. The witness was reluctant to reply on behalf of all other officials, but confirmed that he took action only after receiving the video clip on 1 August 2018 with regards to his scope of duties as the communication officer. As to whether there was an entry at the Mdantsane police station prior to 1 August 2018, which was also a bone of contention by the defense, the witness states that he did not want to comment on this since he maintains that will or is not known to him. Although the case number is indeed 0608-2018, he cannot commit to say if any entries were made by any other officials regarding the incidents in any of the registers held at Mdantsane police station. He confirmed that thereafter he did not play any further role in this matter, as he is not an investigating officer but a communication officer, and that with certainty he is able to say that his only role was to receive the footage and to forward the footage. The witness confirmed that he deposed of a statement and fully appreciates the procedure as far as it pertains to the truthfulness of the statement and the consequences of taking the oath. It needs no further discussion. A statement was then handed to the witness, as well as the court, being a statement deposed by the witness. Again, he confirmed indeed it to be his statement and signature. The contents of the statement was then read out step by step to the witness, who confirmed paragraph 1, where he identified himself, his rank and contact numbers. Paragraph 3 was deemed important by the defense and read out. Therefore, for record purposes, the court will repeat the content as read. On 1 August 2018, I received a video clipping to my official handset depicting an individual firing shots from a firearm and later handing the alleged firearm back to another individual during the 5th EFF celebrations held at Sisa Dukashe Stadium, Mdantsane, East London, CAS 0608-2018, from Captain Marley Govender of the Sept Provincial Head Office, Communication Office, Eastern Cape. He was asked to confirm if that paragraph is correct, which he indeed confirmed as correct. He was then requested to confirm if there was indeed an event held on the mentioned date and to bring under the attention of the station commander, of which he did, and he had confirmed that statement placed before him as correct, and that the oath was taken on 7 August 2018 at 15:20 p.m. and that it was taken by Colonel Swartboy. It was then put to the witness that the statement does not state that he had sent the footage to the investigating officer, Colonel Swartboy. The witness confirmed that there is no mention of Colonel Swartboy in his A7 statement. The question is as to why it is not entailed in the statement. The witness explained that he was following the instructions he received and acting on the requests that were made by Captain Govender, which are the specific aspects that are covered in his statement and what was needed for the statement. Further, that it may have been a mistake not to add it in his statement, but he knew that he would be called to testify in court and will then testify regarding the aspect of his evidence. It was also not pointed out to him by Colonel Swartboy at the time he made the statement. The witness confirmed that in his statement he refers to an individual and does not mention any specific person. The reason as to why he did not mention any individual is because he knew he had to wait for a facial identification expert, and during the time of making the first statement he had not yet received the said information. He, however, confirms that he knew who the people in the clip depicted, the clip that was viewed by him, but he had to be professional and wait for the report. Therefore, he agreed to the submission by the defense that it was, in his view, fair at that point not to mention a person but to refer to an individual. On being asked what he meant when saying handing the firearm back, the witness explained in this case it is to give a person a firearm. The person took it and left with it. It was then put to the witness, and the court will again quote verbatim, "I disagree with you, sir. There is no reason to make this a special case. I only hand something back if I have received it from somebody. Do you agree?" The witness replied, "It is fine if that is the defense's opinion and may disagree with him, since he stated it the way he saw it and the defense might see it in a different way." Advocate Hodes placed it before the witness that he still disagrees and that he will show him why, and requested the witness to watch the video, being video footage clip 3. The witness viewed the footage and was informed he may return to the witness box, as he had now watched the footage and has not requested anyone to stop the footage during the time he viewed the clip. It was then put to the witness as follows: "So do you agree that there is no handing over of a firearm on the video?" The witness did not agree with that submission or statement. He was asked, if that is so, why did he not stop the video to show everyone that what he is seeing? The witness explained that he was watching the video closely and carefully in an attempt to see if he sees what the defense is referring to, and he does not see what they are seeing. It followed by the statement, "So you did not see a handover of the firearm on the video. Do you agree?" The witness did not agree with this statement. The video was then played for the witness to view again, with the request to show the defense where it shows that a firearm was handed over. The video was played and it was put to the witness by Advocate Hodes. He is now challenged to show the handing back of the alleged firearm. The witness viewed it and stopped the footage, saying, "Stop, that is where it happened," unquote. After this exercise and the replay by the witness, it was put to him that there is no handing over on the screen in the video that you have shown whatsoever. Do you have any comment? And the witness complied that he still maintains that there is a handing over. It was then put to the witness, I quote, "Show me the firearm, sir." At the spot where the video clipping was stopped, you cannot even see a firearm. The witness replied saying, "As we all see it, that he was carrying a firearm and Mr. Snyman came nearer to take the firearm. That is where they exchanged. They exchanged the firearm, and if you look clearly, after a second, Mr. Malema was no longer carrying a firearm." It was again put to the witness, "So, you do not see a handover, correct?" The witness disagreed once again with the statement put to him. It was further put to the witness that you do not even see a firearm being exchanged from hand to hand. And the witness disagreed with that statement as well. The dynamics of cross-examination now changed, and this is an important portion of the cross-examination. And it was put to the witness then, it is because he is not telling the truth, as all who is watching this video and we do not see it, and there is not a point that you can show me the firearm going from one hand to another. The witness replied that indeed what he is saying is the truth. Firstly, and I quote, "Let us look what happens with regards to Mr. Malema, what he has in his hand, and then thereafter look at them when they are meeting up there. As they are meeting, and look after them meeting up, then there what happened, because you can see that indeed they are exchanging a firearm." This was not welcomed by the defense, and Advocate Houders put it to the witness that you do not, sir. The item could easily have been could easily have been put down, put on a table, given to anybody else. You do not see it go from, as you call it, Mr. Malema to Mr. Snyman on any video that you have been shown in this court. The witness disagreed with the above statement put to him. He also confirms that he has not been shown any other video clippings, and whatever he had read about the incident at the time, he no longer has. This comes from a question based on if he had read any articles or reports about the incident. And it was then put to the witness that all these documents was discarded by the witness. The witness replied, indeed it was not discarded by him. He merely left it at Mdantsane when he was appointed or moved to Pretoria. Dealing with the viewed footage, it was put to the witness that he cannot tell what type of rifle it is, and that is why he only stated it looks like a rifle. The witness replied that that is good to say that it looks like a rifle. However, he cannot say what model rifle it is. Therefore, it was put to the witness, he cannot then dispute that it was indeed a stage or a TV gun. The witness stated that firstly, that he did not understand the question and it is to be repeated, which was kindly done. That it may also be a TV gun, to which the witness replied that to him it appeared to be a rifle. The witness was shown a statement marked as A94 in the docket. The normal questions pertaining to authenticity was asked and confirmed by the witness. There is no need to repeat the procedure, and further that it was dated and signed on 17 March 2018 at 11:35 a.m. at Mdantsane. Here I need sure I brought one, thank you. Sorry, I just want to. During the EF Sisa Dukashe Stadium, Mdantsane, he was further informed that Colonel Muko, being the responsible person appointed He did so and started to the video footage. Again, the witness was told he is now telling another untruth, and he replied to his understanding he was responding to the question regarding his statement with regards to the video footage, and the statement now shown to him does not refer to the footage. It was put to the witness that his understanding of the questions is false and that the record will reflect it, and if he wishes to apologize at this point, he may do so. And the witness replied that in all honesty he thought that the question he was answering to was regarding the video footage and nothing else. And the scene was reconstructed then by Sergeant Punzi of the local criminal record center relating to where the cartridge casing was found. The sealed exhibit bag was then booked into the SAP-13, sealed as Mdantsane, and he stated, if he recalls correctly, it being SAP-13-688-2018. He was also informed that the viral footage was forwarded to Captain Muko by Captain Marley Govender from the Provincial Communications Office. On the same day, thereafter, a request was made to Captain Muko to forward the viral footage, which was on their official handsets, meaning their cell phones, to his official handset, meaning that of the witness, Colonel Swartboy, for the purpose of extracting and to assist during the investigation process. The footage was forwarded to the witness by Captain Muko, and the following day he had sent a request to DPSI East London office to assist in extracting the data, therefore meaning the footage, the viral footage, and to assist with still photos, compiling a photo album from the viral footage. The witness then handed his official handset to Sergeant Francis and Captain Botha from DPSI Digital Lab, Eastern Cape. A request was made to extract the viral footage which depicts accused 1 firing shots and accused 2 receiving the firearm from accused 1, which appeared to be a firearm. The witness received a CD and still photos from Captain Botha in a sealed evidence bag which contained a photo album. The witness also requested now retired Warrant Officer Steenkamp to complete a facial comparison to identify accused 1 and 2, or if possible to identify accused 1 and 2 from the photo album and CD that was recorded. A report was received from Warrant Officer Steenkamp indicating that accused 1 and 2 could be identified via facial comparison methodology. He further added that the exhibits handed to him or received from Captain Botha was also booked into the SAP-13 register at Mdantsane police station, or I would say at the exhibit store. On further investigation, it was established that the company, Tactical Security Company, and accused 2 being a part of the company, was contracted to Mr. Malema for security purposes. On that basis, the witness applied for a search warrant at the Durban Chief Magistrate's office, which was granted on the 10th of August 2018. The reason for the application was based on the cartridge casing that was recovered, and therefore to possibly match the cartridge to a firearm or rifle belonging to Tactical Security Company, i.e. Mr. Snyman. The cartridge casing was a .223 caliber On 11 August 2018, the search warrant was executed. He further confirmed that General, then at the time being Brigadier Govender, had assisted him in this regard. They arrived at the premises of Tactical Security during the morning, and they were later joined by Mr. Snyman. During the consultations, they informed Mr. Snyman they have an authorized search warrant, which was granted by the Chief Magistrate Durban office, and provided him with a copy thereof. Mr. Snyman informed them that he wanted to consult with his attorney first, who happened to be Advocate Carlitz in this matter, who during that time was conversing with Brigadier Govender at the time. Advocate Carlitz informed Mr. Snyman that it was that she had authenticated the search warrant, and Mr. Snyman therefore thereafter cooperated and assisted them throughout the process. He testified that Advocate Carlos diffused the situation, as they were afraid when Mr. Snyman said he is going to phone Mr. Malema. However, this was also diffused by Advocate Carlos. Thereafter the process, Mr. Snyman assisted in providing them with 12 rifles with the same caliber cartridge cases as per the investigation. All the said rifles were sealed in evidence bags in the presence of Mr. Snyman, who also signed for the acknowledgement of receipt of the said search warrant, including the handing over of the 12 rifles. He further testified that the responsible person on the search warrant was one Mr. Mduli, who was, if memory conserves, hospitalized at the time, as per the information they received from Mr. Snyman, and that he was the senior director and he was the key holder at the time the search warrant was executed. The 12 rifles was then transported to Brighton Beach Police Station in KZN, where it was booked into the exhibit register and booked out again for transportation to the Eastern Cape Forensic Science Laboratory, Ballistics section. The witness was personally involved in the transportation of the 12 rifles to the Eastern Cape Forensic Science Laboratory, and added that since Mr. Snyman was fully cooperating, he also informed them that all the rifles was not present at the premises, as some had been booked out as per the register, and could therefore only provide them with the said 12 rifles. With the assistance of Advocate Carlitz, they had managed to come to an agreement that the 12 rifles, after forensic analysis, will be returned, and thereafter the next batch will be taken for analysis at the ballistic section, and it happened in that manner. The rationale being to keep the business in full functioning mode. The said 12 firearms was then handed in at the Forensic Science Laboratory in Quebeca, and Colonel Mgwadleka received and acknowledged receipt thereof. The IBIS testing would determine if the rifles can be classified as firearms and in terms of the Firearm Control Act, and if it can be linked to any crime or alleged crime. And on completion of the ballistic examination, he was personally involved in the return process of the rifles as per the agreements that were in place with Advocate Carlitz at the time. The firearms were then taken back to Brighton Beach Police Station, where it was handed over to the commander to hand over to Mr. Snyman. With regards to the other 14 rifles that was transported to the Eastern Cape Forensic Science Laboratory, the witness was also involved in that process with the same conditions and process that was followed as per the first 12 rifles that was taken for testing. The witness testified with regards to the transportation of the second batch of the firearms or rifles. He was not personally involved in the transportation thereof. He had received a report that 5 rifles were retained by the ballistic unit in Port Elizabeth and 9 was transported to Brighton Beach Police Station. Thereafter, as per the arrangement, a further 14 rifles were transported to Port Elizabeth for ballistic testing and analysis. After completion of the testing of the last batch, 1 firearm was retained by the ballistic unit and the balance was returned to Brighton Beach Police Station for their handing over to the lawful owner. As testified, the previous 5, he testified that were retained were all returned, save for the 1 rifle that was part of the last batch transported for ballistic testing. The firearm that was retained was CN SPA 249-14. Since the report that he received from the ballistic testing unit was that the said firearm or rifle was linked to the cartridge casing that was found and handed in the SAP-13 exhibit store and analyzed by Warrant Officer Becker of the Criminal Record Crime Science Investigation Unit, also based in Port Elizabeth. There was a further request for the analysis of touch DNA and fingerprint analysis. It, however, was not linked in any manner. That meaning as far as it pertains to DNA and fingerprints, just for clarity. The investigation continued and information was received that Gearhouse Company was contracted by the EFF to erect the stage and provide audio-visual equipment and lighting, music and CCTV footage. A Section 205 Act 51 of 1977 application was made and applied for at Mdantsane Chief Magistrate's Office, requesting Gearhouse to make the CCTV footage available for investigation purposes. The said application was granted and Gearhouse assisted with handing over the relevant footage. Brigadier Governor, now General Governor, was tasked to assist in that regard. The footage was provided and still images was provided and a photo album was also compiled or provided. At this point, the witness testified that Warrant Officer Steenkamp stated in a report that no facial identification was possible based on the footage and photo album she had then received as per the request. The witness also requested, Sira, via the regional manager, Mr. Stander, to establish if Mr. Snyman is registered as a security official with the required authority, which was confirmed, and further established that Mr. Snyman indeed has the required competency certificates to possess a handgun, rifle, and shotgun. It was also established let me not say it was established, but regarding the competency, etc., that aspect I will deal with when the court deals with the evidence of Colonel Janssen. The witness testified that with regards to the viral footage that was downloaded from his official handset, he informed the court that he did not find the source of the viral footage during the investigation, nor the media house that forwarded the viral footage to Sept and to the social media platforms. The viral footage was viewed and he could clearly during the viewing of the footage see that Mr. Malema in the footage is using a firearm. He confirmed that he is not a ballistic expert, but on the viral clipping one can clearly see the muzzle flash. And due to his experience during their shooting practices, when they fire live rounds, there will be muzzle flash. Further, the viral clipping, after the shots were fired by Mr. Malema, he then turns as if he is approaching Mr. Snyman, and then there is an exchange of which you cannot see what they are exchanging. However, the Gearhouse footage is much clearer. It does have different angles, and one can see to the side of the stage where Mr. Malema is firing shots from the firearm and then turns back again and hands it over. In the short clip, you could clearly see that the second clearly see that there was now also shots fired. The muzzle flash is not clear in the gearhouse footage, and in the view of the witness, the gearhouse footage is clear that the shots were fired close to the place where the cartridge was recovered. He testifies that he is referring to the direction in which all the shots were fired and not the actual spot. The witness testified that on receiving the gearhouse footage was a mere confirmation of the incident of the EFF celebration on that particular day, which was in line with the viral footage that was circulated and trending. After the investigation was completed, all the statements, reports, exhibits, and case docket was referred to the NPA for perusal. Further case dockets registered by other parties were also mentioned, amongst others being the AfriForum. After perusal by the advocate on behalf of the NPA, further investigation was required, and therefore additional statements were obtained from various witnesses at the request of the NPA, including additional reports that were received. Thereafter, statements were requested from Mr. Malema, and prior to the statement, the rights of Mr. Malema was explained by Brigadier Governor regarding the constitutional rights of Mr. Malema. I am mindful that Brigadier Governor was not called. I'm merely repeating the evidence of that witness, but whether it is a fact in dispute will be decided at the appropriate time. After which Mr. Malema had indicated through his statement that he denied the allegation and opted to explain his version in court. The docket was then returned to the NPA, where after subsequent summons known as a J175 were issued with regards to accused 1 and 2 and served on accused 1 and 2. The witness confirmed that with regards to the seal bag and exhibit bag numbers, he had deposed of 22 statements, and on concession by the state confirmed that he cannot from memory recall all the seal bag numbers of each exhibit to which he deposed of. A statement, however, he is able to confirm that while handling the said exhibits, it was not tampered with or attempted in any manner, and all seal bags and numbers remained intact. He further confirmed that there was no tampering with the footage and the chain evidence that followed in any manner. The witness testified that he received the viral footage and it was forwarded to his official handset, his cellular phone, which he uses on a daily basis. He personally handed his handset to Sergeant Francis at the digital lab where extraction was done, and the handset was handed back to him. Since he is not familiar with the processes followed during or after extraction of the data, he is however certain that the data that was collected or extracted was indeed correct and kept safe. Therefore, there was no need to leave his handset with Warrant Officer Francis or Captain Botha. The witness confirmed that he had viewed the video footage clips recently, especially the 2 clips received from Gearhouse Company, and the footage now termed as the viral footage. The defense at this point had no objection, as the state inquired whether they are accepting the fact that the first 2 video clippings are referred to as the Gearhouse footage and the third clipping being the viral footage, to which the defense agreed, and there was no need to continue questions in that regard. I'll get to cross-examination now, just 1 second, sorry. You go. Cross-examination by Advocate Hodis on behalf of Accused 1. The following is noted. He testified that he cannot comment if it is unusual that a colonel employed by Sept would be allocated to investigate a docket. However, if a docket is assigned to a detective, then such detective will investigate the docket. He confirmed that he obtained 135 statements. He further confirmed that on arrival at Sisa Dukashe Stadium, he obtained permission from the stadium manager to proceed with the investigation of the premises. This was followed by questions pertaining to the 5 members from the VIP unit that were present and assigned to the protection of Mr. Malema, and as to why he had not testified about it, he replied that it was not deliberate but a mere omission. Thereafter, the names of the 5 VIP members were read out and the statements that they made. The witness testified that he was aware of the 2 members who are based in East London and confirmed that they do not state that they observed anything on the night in question. He confirmed that he interviewed Lunga Mbele, being the individual who scrutinized the tent structure and found no damage. It's also an omission since the investigation of this matter was vast. It continued in this manner, and mention was made of the following persons interviewed who had reported that they had no knowledge of the incident, that being Sergeant Koleka, no persons from BCM or the police. With regards to the reconstruction of the scene, he explained that it was done with the assistance of the lady who pointed out the spot where she picked up the cartridge. He was not able to testify regarding the details and measurements. Apologies. It was put to the witness on behalf of accused. Just a minute. I may have duplicated a page here. Just a minute. Oh. When I refer to this part, Advocate Matthews, it still forms part of Advocate Hodis' cross-examination. I was just checking. I am still getting to yours. It was put to the witness on behalf of Accused 2 that the actual firearm in question was not in East London on the date in question, to which the witness could not confirm or dispute. It was not within his personal knowledge. The witness confirmed that DNA and fingerprints were not linked to Mr. Malema in respect of the said firearm. He also confirmed that the house of Mr. Malema was not searched, and he had not found Mr. Malema in possession of any firearm which was not registered to him. Concerning is the following statement put to the witness. I quote, "All right, so we go then to the actual event. You agree that the ground staff that you interviewed after the event were not present during the event on 28 July 2018. I've made a note for myself here mentioning that indeed the grounds or cleaners, the 2 were present and attended the actual event on the 28th of July 2018. Since they were on duty. The witness replied that he will not know and confirmed that no eyewitnesses came forward to testify that they were Sept members attached to VIP protection services and had seen anything untoward that night. He further confirmed that the only basis of the complaint is with reference to the viral video footage, and continued to say it was the viral footage that was circulating and that it was twofold, the viral footage and then including the cartridge casing that was linked with the firearm that was presented to the ballistic testing unit. The witness confirmed that he did not know who the person was that recorded the original footage that went viral on social media. He had attempted to search for the said individual, but he was not able to find the person. A reference was made to the 23 statements deposed of by the witness, and it does not mention that he tried to trace the source of the viral footage. With regards to the 23 statements deposed by the witness, I feel obliged to state that it is his evidence in chief, since he was part of collecting exhibits, handing in exhibits, receiving exhibits. For each of those requests, a statement would be deposed of. So 23 statements is not unusual. It's clear that most of them relate to the chain evidence. My assumption. The questions that followed pertain to the handset of the witness, who testified that he had handed his handset to the ballistic unit and informed the member that it was his personal official handset, and it was not an attempt to validate the chain evidence. It was part of his investigation. He could not comment on hashtag value, as it does not fall within the expertise of the witness, including the downloading of the footage onto a hard drive. He further explained that after the data was downloaded, he then only directed the forensic unit to extract the 2 clips that was viewed in court, the 2 gearhouse clips. It was put to the witness that he is aware that the video footage may be manipulated, and the witness replied that he is not familiar with that concept. Whether manipulation was possible in the year 2018, etc., will be dealt with by court when it reaches the stage of the proceedings. It was further put to the witness that one will get on TikTok, you can put someone else's voice with your picture, and that he knows this happens with memes, with all different things on phones these days. And the witness replied he's not familiar with that type of IT. Once again, I will refer to AI and its inception, and when it came to realization at the appropriate time. Sorry? I thought you whispered to me. It was put to the witness then at that point that he cannot say it was not a blank firearm. His reply was, I cannot say it was a blank firearm or not. Advocate Hodes obtained instructions from his client at this point, and on returning, he placed the following statement before the witness after obtaining instructions from his client, and it was phrased as follows: I'm instructed to put to you that the firearm that you see on the video is what is known as a blank firearm, and whether he has any comment. The witness replied, as he had done before, he is unable to say whether it is a firearm, real or otherwise. It was then put to the witness, you cannot dispute that, do you agree with me? The witness replied, I cannot indicate whether it's a real firearm or not. He also confirmed that he did not mention in his application to obtain a search warrant for the premises of tactical security that the object appeared to be a firearm. That would mean I am referring to the actual application for the search warrant. It was not mentioned that the object appeared to be a firearm. He also testified that he is not aware if any stage/TV firearms reflect muzzle flash. it is not within his knowledge. Photo or Exhibit A3 depicting the scene was shown to the witness, and the content thereof was discussed and placed on record. The witness confirmed what is depicted in the said exhibits pertaining to the scene as correct. Ultimately, it resulted in the question or statement, "You cannot prove the firearm used is a real firearm or not." The witness stated again he cannot comment on the statement placed before him. Cross-examination by Advocate Matthews on behalf of accused 2. He confirmed that the docket was sent to the perusing state advocate at the time. As far as he is aware, the charges in respect of accused 2 related to supply a firearm, and confirmed that the charges were shown to him. It was put to the witness that no evidence was presented to show accused 2 contravened the provisions of Section 120, subsection 10A of Act 60 of 2000. The witness stated he hears what is being said to him. He explained that his role was to investigate and to comply with requests, if any, when received from NPA, and he had investigated the matter to the best of his ability. In respect of the count alleging that Mr. Snyman failed to take the required reasonable steps and precautionary measures, the question posed was whether Mr. Snyman created a risk to safety of others, to which the witness replied yes. He also confirmed that Mr. Malema was under the protection of VIP protectors from Sept, and there were 2 from the Eastern Cape which he knew about. As far as the other 3 protectors, he was told by Brigadier Governor that they were sent by headquarters and he did not interview them. That was done by Brigadier Governor himself. He confirmed that it would be standard procedure that should any offence be committed in the presence of any police official, such official should respond and act immediately. It was put to the witness that this matter is politically motivated, to which the witness replied he is not aware of any such facts and not aware of any political interference in this matter. He confirmed that he is aware of the plea and the plea explanation that was provided in court by accused 2. And it was further canvassed or placed before the witness that Mr. Snyman denies he ever possessed a .223 loaded Norinco firearm, or that he had a shotgun. In fact, he had a shotgun with a fold-up dash-in butt, to which the witness replied he had finalized his investigation and the facts are before court. The witness confirmed that a list of firearms of Tactical Security Services were obtained by Captain Janssen, and the exhibit is indeed before court and will be dealt with at the appropriate time. He further concedes that if Captain Janssen stated that the SPA 249-14 was booked out to one Larry Mavundla, he accepts it as a fact. He did not personally interview Mr. Mavundla. However, he is aware that a Section 205 Act 51 of 1977 application regarding the movement of Mr. Mavundla via cell phone was obtained and established that he was indeed in East London on the date in question. It was further put to the witness that his client instructed him that Mr. Mavundla flew to East London from Gauteng, and therefore he could not have had the firearm with him to fly to East London. Therefore, the firearm was still in Gauteng. The witness confirmed he received the ballistic reports from Colonel Mgwadleka and that a unique mark in the neck was noted and matched to the cartridge, and further put to the witness that the report does not state that there was anything wrong with the firearm, for example, that the breech block was changed, etc. The witness replied he only received the report indicating the firearm was linked to the cartridge that was recovered. It was further put to the witness that surely one cannot just go out and buy spare parts of a firearm. This was not within the knowledge of the witness. I will deal with this statement during the course of further witnesses called. With regards to the video footage, it was put to the witness that it does not depict or show that Mr. Snyman handed a firearm over to Mr. Malema, to which the witness agreed. The witness confirmed that he is aware that the gearhouse footage was inadequate for identification purposes. Therefore, what was left is the viral footage, to which the witness agreed that was sent to his mobile phone. The source, he explained, was not traced. The search warrant application procedure was discussed and questions posed, which was answered adequately. Search warrant being now the premises of tactical security service. It was also put to the witness that Mr. Snyman was not contracted for the protection of accused 1 on that evening. It was the VIP protection unit. The witness again repeated he was aware of the 2 from Eastern Cape. The court will return to that statement made or placed by Advocate Matthews. It was then put to the witness that none of the VIP protectors saw accused 1 firing a shot, which the witness accepted, and further put to the witness that the VIP protectors were on stage with accused number 1. Court will revert to that statement as well. Re-examination by the state of Colonel Rodney Swartboy. The witness clarified and testified that it was the cartridge that was sent for DNA analysis and not the firearm. Questions by court were as follows. The witness testified that he will not know whether members of the VIP protection unit was placed during the event, and during the interview they had indicated that they were present at the stadium. 2 of the members' statements were obtained by him. However, the other 3, as mentioned, obtained by Brigadier Governor. The 2 members that he interviewed informed him that they were outside, not on the stage or near. However, he was not able to recall clearly. Safe to say that they were present. He is not able to see or identify if these members were on the stage when perusing the video footage. Question based on the court's questions, there was none from the state. Advocate Houders, on behalf of accused 1, the following is noted and placed on record. It was placed to the witness that the close protection officers had to be close to accused 1 to protect him. The witness replied that he does not know the protocol applicable pertaining to close protectors. It was further put to the witness that 2 of the protectors, being 1 Kare and Chahuka, said that they were both on the stage at the time. There was none on behalf by Advocate Matthews on behalf of accused 2, and the evidence of Colonel Swartboy was then finalized. Keep in mind, the evidence has been placed on record to outline what the state then intended or led thereafter in support of the statement by Colonel Swartboy. Just want to establish which one will be. I will deal, I think, because of time, with the 2 witnesses which were actually in event very short in nature, and that will be the evidence of Sarul Johannes Kruger He testified that on 11 August 2018, he was a captain in the South African Police Services stationed at Brighton Beach Police Station, KZN Durban, with 35 years experience in service. On the stated date, he was the Vispol Operations Report Commander that included the management of the exhibits at the station. He confirmed that he received a number of firearms on the 11th, 17th and the 24th of August 2018. He received 22 firearms on the 11th, and on the 17th he received 14 and a further 14 on the 24th of August 2018. The first batch was received by him from Brigadier Govender, who brought the firearms to the witness at the Brighton Beach Police Station. The second batch was received by him from Mr. Snyman himself, and he brought the firearms to the police station as well. The third batch was sent to him by Detective Colonel Swartboy. With regards to the second batch of firearms that was brought to him by Mr. Snyman, which was 14 in total, and on receiving the firearms, they were all photographed and sealed in exhibit bags, and photos were taken of all the sealed exhibit bags, after which he entered it into the exhibit register SAP 13890-2018. The witness testified that the firearm in question, being the SPA or CN SPA 249-14, was amongst the batch of firearms brought to him by Mr. Snyman in person. The said CN SPA 249 was sealed in exhibit bag PAR 00238-256. This firearm was sent along with the remaining 13 of the same batch to the investigating officer Colonel Swartboy, who signed for the firearms and left with it. The firearms was collected and signed for by Colonel Swartboy on 17 August 2018. The witness further explained that photos was taken during the process, meaning a photo was taken of the firearm, thereafter it was placed in the sealed exhibit bag, and a photo was taken again. The witness was directed and shown photo 40 and 41 and 42 of the photo exhibit album, and he confirmed that the sealed exhibit bag number is the same as the number he testified, being PAR 00238-256. 13 of the firearms of the second batch was returned to Mr. Snyman. However, the CN SPA 249-14 was not returned to Mr. Snyman. He also confirmed that in fact all the firearms in all the batches were returned to Mr. Snyman on various dates, and the only firearm that was not returned amongst all the firearms was the CN SPA 249-14, which he sealed in seal exhibit bag PAR 00238-256. The exhibit was not tampered with, and the exhibit seal bag remained intact. The first batch of the firearms was returned to Mr. Snyman on 17 August 2018, being the batch that he received on the 11th of August 2018, and the balance of all the firearms, with the exception of the CN SPA 249, was returned to Mr. Snyman on 31 August 2018. There was no cross-examination in this regard, and it concluded the evidence of Captain Kruger. As stated, I said I'll deal with the exhibits by the state or evidence by the state, but since this is also a very short witness, the court will deal with the evidence of Sydney Henry Stander. He testified that on 1 August 2018 he was employed as the regional manager in the Eastern Cape at the Private Security Industry Regulatory Authority situated in Port Elizabeth, shortly referred to as SIRA, and he has been with the Regulatory Authority for 23 years. He describes that in a nutshell his duties is the primary objective is to regulate the private security industry by effective control or exercising effective control over the occupation of security in the interest of public and the national interest. During December 2019, he was requested by the Septs to assist in assessing the profiles of 2 security officers, being Mr. Kolani Larry Mavundla and Mr. Gerardus Adriaan Snyman. In both instances, he was required to access the authority database. Therefore, he was able to confirm the status of their registration with SIRA as well as their training on record with the authority. The court does not deem it necessary to read out the qualifications pertaining to Mr. Mavundla or Mr. Snyman in this regard, save to mention that Mr. Mavundla was, according to the SIRA records, employed at Tactical Security Services from 1 December 2017, and Mr. Snyman was confirmed to be registered with the authority since 2004. The skills and qualifications of both these individuals were placed on record. The witness explained that the authority has what is called an intervention team. They are activated upon receipt of any information or complaints of newsworthy value or which would suggest any serious alleged infringements of their provisions. Due to the involvement of a security service provider in this instance, it necessitated their further investigation to determine any non-compliance relevant to their mandate. The court notes that at this juncture, a heated debate ensued between the state and the defense that resulted in the court intervening and adjourning, and on resumption, after further debate and reasons on record, the state had concluded the evidence of this witness and there was no cross-examination, and by agreement the statements pertaining to Mr. Larry Mavundla was submitted and accepted by court as Exhibit B1, and that of Mr. Snyman, Exhibit B2, in essence stating that they were both compliant. The court will now deal with the evidence of Colonel David Johannes Jansen. As stated, a Lieutenant Colonel in the South African Police Services stationed at Durban Firearm and Second-Hand Goods Unit, and on 3 August 2018 he had 25 years experience, and he was also on duty on 3 August 2018. He testified that with regards to relevance to the matter before court, he is responsible for firearm compliance, and his duties are to ensure that all people, individuals, businesses, officials, as well as non-official institutions are complying with the conditions under which or for which any firearm license are issued to them. The institution he visited on 3 August 2018 was rendering a security service which are licensed under Section 20 of the Firearms Control Act 60 of 2000, which is dealing with licenses for business purposes, specifically as a security service provider. On 3 August 2018, the witness visited the premises of Tactical Security Services, situated at Lighthouse Road, The Bluff, being a suburb in the city of Durban. The purpose of the visit was to conduct a compliance inspection only. His role and duty was to focus on firearm compliance and the control around it. The request to assist in this regard is contained in his affidavit as per paragraph 1.2 and 3, as he was requested by members of the SAPS to accompany them on the set date. He had assigned Warrant Officer Nika and Warrant Officer Small to continue with the inspection of the registers at Tactical Security Services, as he was needed elsewhere. He testified that Mr. Snyman and Mr. Mduli was present at the time of the inspection. He explained that when he refers to Mr. Snyman, it is indeed accused number 2 before court. The witness explained the reason for his presence to the responsible person, being Mr. Mduli and Mr. Snyman. The members started the inspection by checking the registers and by checking their physical record against the records of the institution. I'm sorry. The witness explains that SAPS has a national database of all firearms that are or has been licensed to any institution or individual. It is also expected from an institution to keep a set of records of all their firearms. He explained that if an institution has a national footprint, meaning it has offices in other provinces, they would have their main stock register at their main registered office, and from that register the responsible person would then delegate the responsibility to whoever is appointed or is responsible at that specific site. Proper written records are required to be kept. The inspection conducted was done over a 2-day period. The institution that was inspected was busy with upgrades at the time, being improving or upgrading the security with regards to the firearms, and when they arrived on the 3rd, being a Friday, and as he had to attend another commitment, they had to continue with the inspection on the following Monday, being 6 August 2018. The total number of firearms, according to the records, were 221 in total, irrespective of the caliber, make, or model. They were all licensed to the institution. There were also no firearms lost or stolen at the institution at the time of the inspection. And since it is known that because of a certain alleged incident that caused the witness to conduct an inspection at the premises of the institution, on paragraph 8 of his statement he listed all the rifles, including the different caliber of rifles, including listing the rifles which were not found on the premises at the time. The witness confirms that the 221 firearms he mentioned were all accounted for in the registers of the institution, including the firearms rifles that have been booked out was accounted for in the registers of the institution. And then as per 826, a copy of the register in an abbreviated combined daily weapons and ammunition register. In paragraph 8, the witness listed the 30 firearms that were not present on the premises. The 30 rifles were accounted for in the register of the institution as being booked out. On the 6th of August 2018, as he was about to leave the premises, he was approached by one Mr. Larry Mavundla, and he brought a .223 rifle Norinco with serial number CNSPA 249, and he had also produced a 9mm Glock pistol with him, serial number YYAYYS508. The witness was informed by the managers that they are volunteering the firearms as they know that it is viewed as possibly being used in the commission of the offence, and therefore they had asked Mr. Mavundla to bring the firearms to the premises. The witness explained that the offences is referring to the incident of East London, where there was a video clip circulating where Mr. Malema was firing a firearm. Therefore, Mr. Mavundla had been requested to bring the firearms in for inspection and possible ballistic inspection. It was said that Mr. Mavundla was asked to return from Johannesburg to bring the firearms to KZN. The firearm in question was, as he had listed in paragraph 8 of his statement, the .223 rifle, semi-automatic, being a .23 caliber. The said .223 Norinco was marked as number 6 on the list per paragraph 8 of his statement, therefore being the firearm that was presented to him before he left on that day. Thereafter the witness left and compiled his report. The firearms were left at the institution for whatever further arrangements or investigations that may follow. The 2 firearms brought by Mr. Larry Mavundla was also left at the premises of the institution when they left. The firearms were detained and kept by the responsible people or owners of the institution for presentation to the investigating officer as they may have arranged. The witness also attached a Section 109 inspection report to his statement. It reflects an indication of all the firearms that was physically checked and inspected. The firearms were left at the premises as stated, as the witness was not privy to the investigations and was only requested to conduct the inspection, which he had done, drafted his statement, including the Section 109 report. He confirmed that accused 2 was present on the 3rd and the 6th of August 2018, and also present when he was about to leave and when Mr. Mavundla arrived. He was told by Mr. Snyman that Mr. Malema's personal protector had just arrived from Johannesburg to bring the firearms and to present it to Sept for inspection. Cross-examination by Advocate Hodes on behalf of accused 1. The witness confirmed he is not a ballistic expert and is familiar with the administrative component of firearm licenses. He also confirms that he has recently been made aware of the fact that replica or look-alike firearms are available on the market, which does not require a license. The witness confirms that some of the replica firearms are available on a website, and I hesitantly quote the name mentioned by the defense and the witness under the search engine, no license needed, end of quote. And that they are also available in a gun store. Some resemble a pistol and others resemble a rifle, even to the extent of it having an extendable butt and that it shoots or fires blank shots. The following statement was put to the witness by Advocate Hodes, and the court will quote from the record verbatim following the above issues. It was placed that these rifles, stroke firearms are very authentic. They look exactly like a rifle or a pistol or whatever they are designed to look alike. Do you agree? Will one tell the difference if you look at them in a store? To this statement, the witness replied that obviously he would be able to differentiate based on the fact that it has a gas cylinder, and a pistol is a bit difficult, he must admit, but not the rifle. There's a bit of a possibility of a defraying attribute, if I can use that word, he quotes on page 3 of the record. It is further placed before the witness that even when one fires those pistols and rifles, one gets what is known as a flash, a muzzle flash. The witness replied that he himself has not witnessed it, unfortunately, but he cannot dispute or agree that it may emit muzzle flash. The witness confirmed the statement made thereafter, being that the principle at the moment was that they are available because no projectile comes out of the barrel and no license is required. The witness, however, explained that he has seen this on a website, but has not had any personal interactions or dealing with such a weapon, and had not worked on the reconstruction of such a weapon before, weapon being the replicas found. Cross-examination by Advocate Matthews on behalf of accused 2. The witness confirmed that the inspection he had conducted showed that all the registers were in order on inspection of the institution. He also confirmed that he is aware that the company cooperated and called all the firearms that were booked out in, but that the investigating officer was in communication with the company as to how the firearms will be handled or dealt with. It was put to the witness that indeed they had all come to an agreement that batches of 10 rifles will be handed over for ballistic testing at a time. The witness stated that he was not part of the agreement, but he was aware of such an agreement. He also confirmed that on the 6th of August 2018, as he was about to leave, he was called by Mr. Snyman as a motor vehicle pulled in saying, I quote, here is one of our guys bringing in firearms all the way from Johannesburg. Unquote. It was put to the witness that Mr. Snyman told him, here are the firearms. Do you want to take it for ballistics? And that the witness replied to Mr. Snyman, no, it is not his job. The witness replied that he honestly cannot recall if that was said. However, he can confirm that the male arrived with a pistol and a rifle and that he was there for compliance inspection. It was further put to the witness that it was said in a joking manner that this is the particular firearm that belonged to Mr. Mavundla, and that it was not in East London on the evening the incident happened. The witness referred to paragraph 10 of his statement, and the witness confirmed that it is recorded that they were told that the firearms were brought from Johannesburg. After several questions about the airline and rules, the witness replied by saying that he does not know if or how the firearm got to East London or not. Relevant in the cross-examination is the witness confirmed that the firearm in question, CN-SPA 249, the registers of the institution reflected that it was in Johannesburg. It was put to the witness that the specific firearm has a butt that pushes in and not a butt that folds. Further discussions and questions pertaining to the availability of ammunition used by the replica firearms and its legality ensued, and the court does not deem it necessary to repeat the discussion between the defense and the witness on that aspect. In regard to the evidence of Colonel Jansen, by agreement and consent of all parties, Exhibit C, being A26 in the docket, the report was then marked as Exhibit C by court. Let's go. Sip of water, then I'll be ready to go with the next one. The court will now deal with the evidence of Dwayne Frederick Francis. I would highlight that indeed the evidence of Warrant Officer or Sergeant Francis was a lengthy process, but in essence I will summarize as best as possible without leaving any detail or important factors raised by either the state or the defense and place them on record. He testified he was a sergeant in South African Police Service in 2018 and attached as an investigator to the Directorate of Priority Crimes Investigations in the Digital Forensic Investigation Unit in the Eastern Cape. He joined the unit in 2013 and received several training concerning computer forensics, mobile phone forensic, and also CCTV footage. I'm not going to list the list of training, it was read into the record. Of importance is he testified that on the 2nd of August 2018, he received a request from Colonel Swartboy from Mdantsane Detective Services to assist him in extraction on a particular phone, and he was also requested to compile a report in that regard. The report was submitted with the consent of the defense and was marked as Exhibit H. Therefore, the relevant exhibit with regards to Sergeant Francis being Exhibit H before court. The nature of the functions performed by the witness was as follows. The mobile phone was handed to him by Colonel Swartboy on his request to download certain videos from that mobile phone. The video footage was pointed out to him, and he downloaded the video footage with the forensic software at their office. The footage was then copied onto a verbatim DVD. The exhibit was then sealed in forensic exhibit bag, and the evidence bag was handed over to Captain Botha for further analysis or investigation. A copy was also then handed to the investigating officer, and the handset was handed back to Colonel Swartboy. His investigation was then complete. The handset or phone that was handed to him was a Samsung SM-G360H mobile phone with IMEI number 3585-551-06-191340-8. The footage that the witness downloaded was the 2 video clips, and he testified that the phone belonged to Colonel Swartboy. He confirmed that the footage was pointed out to him by Colonel Swartboy. that being the 2 video clips were found on the specific device under the application WhatsApp. Therefore, it is taken from the phone handed to him by Colonel Swartboy. By saying it was found under application WhatsApp, the witness explained that the 2 video clips were received via the WhatsApp application, and he confirmed that whilst the said phone was in his possession, he did not tamper with the said phone in any manner, and further that the footage that was downloaded on the DVD handed to Colonel Swartboy was indeed to the satisfaction of Colonel Swartboy. The DVD was sealed in tamper evidence bag number FSC-1239722, being the DVD marked as Mdantsane Cas 0608 of 2018. He further testified that the report he compiled consists of 21 pages in volume, as it explains the procedure that he followed at the office, or the procedure as to how he conducted the investigation on the specific mobile device. The witness was referred to page 19 of his report. This is now by the State Advocate Sisa, to which he testified depicts the photo of the specific handset or mobile phone he used to extract the footage from. And then page 20 contains the relevant DVD that was sealed in exhibit bag number already placed on record, but for record purposes reads as FSC-1239722. That concluded his evidence in chief, and during cross-examination by Advocate Holders on behalf of accused 1, the following is noted. The witness was confronted as to why he did not mention that the specific handset he testified about belonged to Colonel Swartboy. The witness replied he did testify to that regard, which in fact he did in evidence in chief. However, the bone of contention raised by the defense is that it is not specified in his report, and he continued to say that the report states that the phone was handed to him by Colonel Swartboy at his office. Yet the issue remained that the report does not in any clear terms state that the phone belonged to Colonel Swartboy. This led to the following statements made to the witness. As has been the procedure during this judgment, the court will quote verbatim from the record. Quote, "You will see here, you say that he approached you. You say in paragraph 6 on the 2nd of August, a request to assist with the extraction of data from this particular mobile phone, which we have already established you never identified as his, that being of Colonel Swartboy." The witness conceded to that aspect in as far as his report does not state it is the property of Colonel Swartboy. He explained that he handed a cellular phone to him, a mobile phone, and it was put to the witness that Colonel Swartboy told the witness that it is his phone, to which the witness agreed. However, he had also not recorded that sentence in his statement. He explained that he did not ascertain as to who the owner was of the said mobile phone, as the request was to download the video footage and not to ascertain who the owner was. This line of questioning continued for a length of time, and I will, for purposes of this record, have to repeat what was put to the witness, which will clarify the bone of contention and the concessions made during the questioning, and after all then read out the reply by the witness. Read out. The following statements were made to the witness. You see, if one reads your statements and your report, you will see here that you were approached, and you create the impression that you were approached on an objective basis to download all the data from the mobile phone. Nothing could be further from the truth. Do you agree with me? The witness did not have the opportunity to respond, as it was further put to the witness, and the court quotes, "You say that the downloading of all data from the mobile phone was done as set out in your report attached as Exhibit D1. You did not download all the information on the phone, otherwise we would know from your report whose phone it was." The witness replied the request was to download video footage. The statements continued in the following manner. Quote, "Even that is not accurate, sir. You did not download all the video footage on the phone." The witness now, for the first time, replied to these statements made and answered and explains that what has been clear from the onset, the request was received, whatever that may mean. It continued with, "You are not answering the question. I'm going to repeat it again. Nowhere do you compile a report where you downloaded all the video footage on the phone. Do you agree?" The witness replied, "Yes, but the meaning, yes, meaning it does not reflect in the report, not that it was not done." So what happened here, if we can summarize, is Colonel Swartboy came to you, he gave what was his own phone, which you do not disclose, and he said download all the information which you read to me, and download all the video information which you did not even do. Meaning, at this point, it is put to the witness that he did not download all the information as requested. The witness stated clearly that the video footage was downloaded. Then Colonel Swartboy pointed out what video footage he is requesting. Advocate Holders then put to the witness, "You have now drawn the distinction. You never downloaded all the video footage. He brought you his phone, he opened a particular WhatsApp and said download this WhatsApp, and that is what you did." The witness replied and explained that is not how the system works. It downloads the video footage in its totality, and then from the downloaded footage, it is where Colonel Swartboy pointed out the two respective video footages that he requested. The witness was then questioned on if he says it downloads, or the system downloads the video footage, did he then in fact download all the video footage from one WhatsApp on the phone? Because this is the distinction the defense is trying to draw. The witness replied that the video footage falls under the category of media. All media under a folder that includes videos, pictures and audio. The forensic software only gives one the option to select videos or pictures or audio. Therefore, in this instance, the witness selected video footage or a video folder. It is because he was requested to download video footage. Then, in summary, it was placed before the witness. Therefore, sir, you were directed to one particular video to download, that particular video. The witness again replied, all the videos were downloaded, and from there, the requested specific video footages were pointed out, and that he had stated in his report. Advocate Otis then placed it before the witness. Your report does not come close to saying that, sir. It says the downloading of all data from the mobile phone was done, and that nobody corrupted and tampered with it. And if we turn to your report, he was taken then through the report and with specific reference to page 14 of the report. I quote, to assist with the extraction of data from the mobile phone. The paragraph was read out to the witness and the statement was put to the witness. You did not extract videos. You went to videos and you were directed to a particular video that you then downloaded. Once again, it remains the same statement, phrased in a different manner. The answer by the witness remained the same. I downloaded all the video footage. He, however, concedes that it is not clear in his report. The witness also conceded that his report is not detailed and that he had not stated clearly in good wording that the phone is the property of Colonel Swartboy. It was put to the witness when testifying. He said that Colonel Swartboy requested him to download certain videos from the phone. The witness agreed and concedes again that it is so, but it is also not clearly stated in his report. And he also confirmed that he does not know the original source of the WhatsApp, and it is not included in his report that it is a WhatsApp received on a certain date and from a certain person. The witness explained that there is a report that is created by the forensic software that was placed on the DVD. That is the downloading of that specific mobile device which the video footage contains. This was also not accepted by the defense, and it was put to the witness that it does not explain anything. It remains unexplained. But I want to put it to you, sir. One of the most troubling features, because there are several that I have obtained from your evidence in chief, is you said that you made another copy that you gave the investigating officer. The witness stated that that was correct, and on being asked why he had provided a copy of the report to the investigating officer, he testified that it is stated in paragraph 7.3, page 21 of his report, the exhibit and the report were handed over to the investigating officer. Let me just rephrase it clearly. In paragraph 7.3, page 21 states, the exhibit and the report was handed over to the investigating officer, and explained that it means the report and the exhibit being the copy of the information that he downloaded was handed to the investigating officer. Further questions in the same manner, now focusing once again that the report does not state the mobile phone belonged to Colonel Swartboy. The witness replied and explained all he knows is that Colonel Swartboy handed over the phone to him, and which he then believed to be the phone of Colonel Swartboy, and explained to the question to what does he base this on, he explained the mobile phone was not handed over to him in a sealed exhibit bag, as it would be if it did not belong to Colonel Swartboy. Therefore, it is clear that it belonged to Colonel Swartboy, because if it did not, then it would be received by him in a sealed forensic evidence bag as per the procedure. Questions return to the fact that when it comes down to the analysis, Colonel Swartboy was present with him because he directed him to a particular WhatsApp. And as to why it is not in his report, he replied saying he once again apologizes to the court that he did not provide a detailed description. Further statements followed, which will be repetitive to repeat. Therefore, it was put to the witness that nowhere does he deal with the gist of the case. The witness asked Advocate Hodis if he may explain and was told which then followed. He was told that the CD that was handed to Captain Botha that was sealed contains the video footage that was downloaded with an additional report of what is used to download the video footage and what type of footage it was, which is the copy is also handed to the investigating officer as the information that was downloaded from the handset. He was then asked to know as to how we will know what is contained in Captain Botha's report. He explained because the DVD contains the video footage and that he downloaded it with a report and an additional report of what software he used to download the record. The witness was asked if he is aware of the value of hashtag, which he confirmed he was, and confirmed it is like a fingerprint to authenticate the forensic information, and he was asked as to where the defense would find that. The witness replied it is found on that CD or DVD that was handed to Captain Botha, and confirmed that it is not contained in his report but in Captain Botha's report. The witness was referred to his report, again paragraph 7.1, stating, I quote, all data found from the above-mentioned exhibit was exported in PDF format on documents to a CD-DVD marked Mdantsane CAS 0608-2018 and sealed in a new tamper evidence bag with seal number FSC 1239722, which the witness agreed with. The issue, however, raised by the defense is if it says all data, the witness explained all data should have been said to be all video footage. It was put to the witness, no, that this is an incorrect and false statement. The witness replied that it is the data that was downloaded, as the system does that automatically. Cross-examination by Advocate Matthews. He confirmed that the mobile phone handed to him was functional, and he confirms he recorded in his report that he did not have a SIM card at the time. It was put to the witness, but it cannot work then if it had no SIM card. The witness replied that the SIM card was not needed to work properly, as there was no phone calls made or received for forensic purposes or purposes of his request. He explained on Being asked why did he not take it out, he explained that he did not take it out. It is how it was handed to him. He also testified he did not place or insert a SIM card in the mobile phone, and it was put to the witness. He recorded in his statement it had no SIM card, and it was a twofold statement, also stating that he also did not look for one, and if he says he does, how does he know there was none? The witness replied there was no SIM card when he opened the phone and removed the battery. He also confirmed that the forensic system used is Cellbrite. That completed the evidence of Sergeant Francis. Which one? No problem. Do we set a time frame on the comfort break? Or may I ask our police officer just to shout, because I'll come right back in, so that there's no pressure on a time limit to your comfort break. The court will adjourn and then proceed with the rest of the evidence. Just to the state and defense, in that short adjournment before we started, between one and I managed to get hold of some of the people involved, and with the request of going beyond 4 o'clock, I'm told it's not possible. Sorry for that, but it says that it involves so many other sections, units. It's not just, if it was just the court, fine, but it involves many other. Okay, sure we can still get a lot done. We can go back on record. Alright, on resumption then, the court will continue with judgment after a few minute comfort break, which we adjourned for. I think I only managed to say the court will now deal with the evidence of Captain Rian Botan. Yeah? That's where the state applied to submit the document before court, and the witness started evidence in chief, to which the defense had no objection and was accepted by court, and the document or report marked as Exhibit J. My eyes. The witness confirmed that he was employed by Sept, and on the 2nd of August 2018 holding the rank of captain and stationed at the Directorate for Priority Crimes Investigation for the Digital Forensic Investigation Unit here in the Eastern Cape. The witness processed the place. My eyes are very tired. Sorry. The witness proceeded to place his qualifications and training on record, and the court is of the view that there is no need to repeat the same, as it is on record at this point and is also contained in Exhibit J. So therefore, on the 2nd of August 2018, he was one of the cybercrime investigating officers at the office. He received a request from the investigating officer, Colonel Swartboy, from Mdantsane Detective Unit. The nature of the request was to assist with the analysis of video footage and to compile an album, a verbatim CD sealed in evidence bag with serial number FSC 1239722 was handed to him by Sergeant Francis. The witness was required to do an analysis on the video footage on the CD and to make still photos, compile a photo album thereof, and if possible, to enhance the images on the still photos. Thereafter, to compile a report on his findings. The witness referred to paragraph 9 of his report, where he stated that he opened the undermentioned or the tamper evidence bag and removed the following from evidence bag number FCS 1239772 and removed one verbatim CD R marked as Mdantsane CAS 0608 of 2018. The said CD-R was placed in a forensic computer, and all data on the CD was copied onto a 2 terabyte hard drive, HP hard drive, with serial number WCAZAC779077 for the analysis of the data. The forensic program MP5 was used to do the analysis on the data. The witness then referred to page 10, paragraph 42 of the report, explaining he had done hash values on the CD, meaning he took the CD and went back to the hard drive on which the cell phone data was stored. He then conducted the hash verification from the CD data on the CD to the data on the hard drive, and it gave him an exact match. He explained that since he had copied the data onto the external hard drive and did a hash verification on the data from the CD again to the data on the hard drive, which he copied over, and that gave him an exact match as well. This is contained in paragraph 4.3 on page 11 of his report. The witness then went back and referred to page 9 and testified that the CD, together with the previous tamper evidence bag with serial number or seal number FDC, that must be a typing error, FSC 1239722, was sealed in a new tamper evidence bag with seal number FSC 1239723 and placed in the safe for safekeeping. The witness then referred to page 14 of his report, which contains or depicts photographs of the sealing and unsealing process he followed regarding the said CD. It is depicted in page 14, 15 and 16 of the report. Page 17 contains the conclusion. A photo album was compiled and attached as per RB2. The still photos from album RB2 was enlarged and enhanced by applying filters in the forensic program M5, and a photo album was compiled and it is attached as per annexure RB3. Color copies was shown to all parties in court and referred to page 1 being in relation to RB2. In respect of photo album RB3, it contains some of the photos in photo album RB2 and enhanced it, meaning that the same photos as in RB2, page 1 of the second photo, explaining that it is the same photo on the left and the one on the right is the same photo but an enhanced photo. Then page 2 is the enhanced photo but further enlarged. And the photo in the photo album is reflected from page 1 to page 22. The witness then returned to page 7 of his report, Exhibit J, paragraph 7.3, referring to the album of the enhanced photos, and the 2 video files were copied onto a verbatim CD marked as Mdantsane Case 0608-2018 for facial recognition purposes, sealed in tampered evidence bag with seal number PAD 005-06846 and handed over to the investigating officer, Colonel Swartboy. The CD received from Sergeant Francis, the exhibit and report were handed over to the investigating officer for further investigation. The witness testified that the still images he secured was done from the so-called viral footage made available to him. The witness was asked to explain what he observed in the video footage and explained to court as follows. On page 1 of 10 of the photo album, there are 2 well, let me put it in this way. The first photos are 2 on the page. It depicts a person and appears if there is a firearm in his hand. Page 2 is still depicting the same person, but now the firearm in his hand is pointing upwards, and it appears as if when looking at the top of the bar, it is going sideways, and it appears as if there is muzzle flash from the firearm. The witness stated he is not an expert in the field, but understand muzzle flash to mean a flame that is seen coming from the front of the firearm. Page 3 still reflects or depicts the same person with the firearm in his hands, pointing up. Page 5 is the same person that had the firearm in his hands. He turned around and walked backwards. Page 5 still depicts the same person. Page 6, the same person that had the suspected firearm in his hands, and he is now talking to somebody. Page 7 shows the same. Page 8 shows a male walking away from the first person shown on the first few photos. Page 9 and 10 is the same person that is walking away. The witness was asked if he is able to identify the persons on the still photos and the enhanced photos, and he replied he is not a facial expert, but from a layman's eye he is able to say that the two persons depicted in photos 1 are accused 1 and 2 before court. The witness further testified that page 10 of his report refers to the hash values, and in paragraph 3, the last paragraph, it is the created time. He explains that when one takes the first two, it is a logical report, that is the Cellbright report, downloaded by Sergeant Francis, and the last 4 rows is the 2 video footage folders that was downloaded. If one looks at the first one, it was downloaded onto the external hard drive by Sergeant Francis on the 2nd of August 2018 at 01:18:17 seconds p.m. and it was created on the CD on the same day at 01:21:33 seconds p.m. Then page 11 of the report, he copied it over onto the external hard drive, and the same day at 01:42:17 seconds, he also explained that the seconds will differ slightly as it takes a few seconds to download or copy the files. He testified that he had followed the procedure with regards to accused 2 as the person depicted on the photos, who had also interacted with the first individual he had testified about, and in his view it was accused 2 before court. He continued to say that in his view the person who fired the shots as depicted in the footage and image was accused 1 before court. Cross-examination by Advocate Holders on behalf of accused 1. The witness confirmed he was not a facial expert and also not a firearm expert regarding explanations pertaining to muzzle flash, and also cannot venture on whether it is indeed a real firearm or not, including whether the individuals spoke to one another. The witness confirmed that he had received a verbatim CD from Sergeant Francis for analysis, further that he had then downloaded the CD contents onto an external hard drive. He also confirmed that he then determined the hashtag values, which he found to be an exact match. The witness was referred to page 9 and 10 of his report, being Exhibit J. It was put to the witness that on page 10 it states, and the witness explains what is phrased as follows: you took the hashtag values of the files from the download of the mobile phone and copied, and files copied to the CD, showing that it is an exact match. And onto that statement, the witness confirmed that it was indeed correct. It was put to the witness that he did not have the mobile phone. All he had was the product of the mobile phone on the CD. So therefore the chain begins at the CD. The witness explained that his chain begins at the point of the hard drive. The investigating officer and when Sergeant Francis copied the data onto a hard drive, and he first then did the hash verification from that hard drive to the CD, and then from the CD to his own hard drive again. The witness was handed a report being Exhibit H, and it was put to the witness I'm challenging you, sir, to show us where you found that he downloaded the information to an external hard drive. The witness confirmed that it's not contained in Exhibit H, which was also confirmed by Sergeant Francis. A further statement was put to the witness. You are comparing that to a hard drive that we do not know when, where, or by whom it was created. The witness asked if he may explain, and the defense allowed him to do so. He explained that all data downloaded at the cyber forensic unit is kept on hard drives. They do not have other storage facilities, so all data is kept on external hard drives in the safe. So he downloaded the data on a hard drive, and that is the hard drive which he then took to see if it compares with the data on the CD. Advocate Hodes proceeded to make the following statement. So you match the hard drive to the CD, and that we have in pages 10 and 11, and the hashtag values match, and you have got the specific times there, and you can see they are only minutes apart, that they were created minutes apart, and it was quoted 01:18 to 01:21 p.m. as per page 10, and when looking at page 11 was quoted to be 01:21 to 01:42. The witness then pointed out that the times mentioned is actually the seconds apart, not minutes, and page 10 states the first one is a logical report PDF that is on the hard drive. The second one is a logical PDF report that is on the CD. So you will see the minutes are different, because after he had it on the hard drive, he cut it onto a CD. So the times will be different, and then every second one is the CD, and every other one is from the hard drive. A further statement to the witness is, the crux of the issue is you define what the hashtag value is and the significance of it, and yet I'm going to give you the reference, Captain. It is in paragraph 5 of your report, page 16 of the record, and the court quotes. And you say here, what is MD5? An MD5 message digest algorithm was developed by Professor Ronald R.L. Rivets at MIT in 1991. MD5 is an algorithm that is used to verify data integrity through the creation of 128-bit message digest from data input, which may be a message of any length that is claimed to be as unique to the specific data as a fingerprint is to the specific individual. In other words, that is your guarantee that that is the exact same information which the witness confirmed to be a correct statement. The witness confirmed that he had matched the hard drive to the CD, but never ever had access to the mobile cellular phone. And in other words, it was then put to the witness, the chain is intact as illustrated by the hashtag values from the CD to the hard drive, but nowhere before that and nowhere after that. The witness agreed in that he did not do a hash verification on that aspect. further paragraphs pertaining to how algorithm was read into the record, and in essence it was then put to the witness that, so here we have a chain that is intact between these two items, the CD and the hard drive, but no hashtag value was obtained of the cellular phone, which the witness agreed with. However, that was not the situation from his side. What followed was statements dealt with during the evidence as testified by previous witnesses, to which the witness had no comment and was not within his knowledge. Safe to add that the witnesses replied by saying that from his experience they also he also downloaded the mobile phones. On a report of the mobile phone, if we download the data onto a hard drive, you cannot change any of that data, and there must be a hash verification on that report from the Cellbrite facility. We all know that is not available in Exhibit H. Have energy for the next witness? Me or the witness? Time. Shall we call time then? The next witness is 1, 2, 3, 4. The next witness is 5 pages. But it contains quite a few exhibit seal numbers, and my eyes aren't playing along anymore. I can do it. It's Philip Becker that I'll be dealing with. Speak up or forever hold your peace. Okay, you have not held your peace, Advocate Ode?
How many words of time?
No, I. All right, then I'll play. Advocate Caesar, let's go. Court will deal with the evidence of Philip Rudolph Becker. The witness is a member of South African Police Services, holding the rank of warrant officer and attached to the Provincial Crime Office in the then Port Elizabeth, with, at the time of his evidence, 30 years and 9 months experience, of which 22 years and 8 months experience as a crime scene investigator. The witness explained that his duties are as follows. He is a criminal expert and functions as a crime scene investigator as well as a laboratory technician. It entails the processing of crime scenes for forensic evidence, which includes fingerprints, DNA, ballistic evidence, as well as other impression evidence such as shoe prints. The witness testified that he received a request on the 3rd of August 2018 from the investigating officer of the matter, Colonel Swartboy from Mdantsane Detective Unit, to process a single exhibit regarding a case he was investigating. He booked the exhibits from the Mdantsane exhibit store booked out at about 8:45 a.m. At this point, due to time and to facilitate proceedings, the state applied to furnish the court with the report / affidavit drafted by the witness to assist the court to follow the evidence, to which the defense in respect of accused 1 and 2 had no objection. In paragraph 4 of the affidavit, the SAP 13 number is recorded as 699 of 2018. The exhibit the witness booked out was a single cartridge case sealed in evidence bag with seal number PA 6001796 He proceeded to process the exhibits in the crime scene laboratory at his office and compiled a photo album documenting the different steps that he had taken with the exhibit. He further confirmed that the photo album is correct and, according to his knowledge, unaltered. Photo 1, 2, and 3 depicts the exhibit bag as testified and visible in photo 2 as PA 6001796 Photos 4 and 5 depicts the single cartridge case, and 6 and 7 shows a fingerprint that he had recovered on the cartridge case. It is noted that the fingerprints are tested against the SUBS database and against the set of fingerprints that he received from the investigating officer. However, no match was found. Photos 8 to 17 show the acting DNA collection from the cartridge case, which, according to his understanding, was also not linked to any person. After completing his processes, the witness resealed the cartridge case in an evidence bag as visible on photo 19 and 20 with serial number PA 60002321818. On the same day, after completing his processes, the witness delivered a sealed reference bag to the Forensic Science Laboratory in North End, Port Elizabeth, and testified that whilst in his possession it was kept safe and not altered in any manner, and all processes he used were non-destructive and visual. The bulk of the photo album was submitted, being photos 1 up to photos 270, and as to photos 1 to 20 was submitted earlier during the evidence, the balance being then 21 to 2070 to 270 was submitted and accepted by court. With reference to paragraph 11, 12 and 13 of his affidavit, he was requested by the ballistic section of the Forensic Science Laboratory to process these firearms and ammunition for fingerprints. The witness confirmed that most of the firearms did not retain any fingerprints. The few prints he recovered did not match any person. This aspect does not require any further discussion by court, as the finding is clear. The witness continued and referred to the court to photos 126 to 131 of the photo album. The photos depict a firearm that he investigated. Photo 126 and 127 reflects the seal exhibit bag which the witness received and visible as PAR 00238-256, and photo 128, the actual firearm removed from the exhibit bag, and 129 reflects the serial number visible on photo 29 as CN-SPA 24914. Then photos 130 and 131 shows the resealed firearm into evidence bag with serial number PAR 000-1252427. The witness testified that the selection of photos depicts the processes that he followed with each and every one of the firearms, where only this specific firearm was relevant to the case, being the said CNSPA 24914. It was processed under Mdantsane Cas 0608 of 18. The said firearm was also marked with the following reference: Brighton Beach SAP 13/890/2018. As a point raised by the state, the witness testified that the cartridge case was delivered by hand by by himself at the Forensic Science Laboratory in North End, Port Elizabeth. The witness confirmed that all the examinations performed by himself were conducted in room 608 at the Forensic Science Laboratory under supervision of a ballistic expert, Lieutenant Colonel Mgwadleka. The witness received the seal exhibit from Colonel Mgwadleka and left it sealed again with Colonel Mgwadleka. From the side of this witness, no further examinations were conducted with regard to the cartridge case or the firearm as mentioned. However, the witness received a request from Colonel Mgwadleka on the 22nd of January 2020 to assist him to video record a shooting demonstration. The witness tested the muzzle flash of the said firearm. He started the recording at 10:36 a.m. at a distance of 2.3 meters from the firearm at an indoor shooting range at the Forensic Science Laboratory. The recording had a digital file number P2U00371 and was approximately 2 minutes and 56 seconds in duration. After completing the video, he was requested to make screenshots or still photos from the videos and each one of the shots fired. The witness then completed a compiled photo album with the images which he marked as shot 1 to shot 5 and handed it over to the investigating officer, Colonel Swartboy. The witness was further requested to visit Sisa Dukashe Stadium in NU2 Mdantsane by Colonel Swartboy to assist with making or taking measurements and plot certain points at an area in Mdantsane. This was done on 19 November 2018. The witness testified that the points and measurements were taken with a handheld Garmin high sensitivity and GPS device, after which he had downloaded the data into the Garmin street maps as well as the Google Earth satellite program. The data and images are depicted in photo album marked as GPS map 1 and 2 and satellite image 1 and 2. With regards to satellite image 1, it depicts a yellow, more or less in the center, 2 points A and B, whereby A is the area that was pointed out to the witness where the podium was approximately located during the incident, and B the area where the cartridge case was recovered. The distance between the 2 points measured 23 meters. The witness informed the court that these are not accurate measurements, as the precise location of the podium as well as the precise location of where the cartridge case was found is not known to him and was pointed out to him by Colonel Swartboy, and also requested that it should be viewed with caution. He also obtained measurements to the nearest house located from the area and which was visible, marked as reference point 7, and the distance between point 7 and the point A was plus minus 113 meters. The second point was also recorded and visible on satellite image 1, right hand side of the stadium, marked with a black dot marked as Funulwazi SP School. This point was marked reference 6, and the distance between point A and point 6 measured approximately 142 meters. In essence, that concluded the function of this witness pertaining to this matter. As to estimations regarding questions pertaining to ammunition, etc., he had elected to leave such aspects to the ballistic experts unit to answer. Cross-examination by Advocate Holders on behalf of Accused 1. Confirmed he received a spent cartridge case on 3 August 2018, sealed in exhibit bag marked PA 60017961006 and that after he examined the spent cartridge and photos were taken, it was placed in a Ziploc bag and then resealed in exhibit bag, evidence bag, PA 600-232-1818. As to what he had done with the original bag, PA 600-1796106, the witness explained that it was stored in their dockets and it is still available in his docket with him in court. He explains that it was done in this fashion as there was a possibility that further examination may be needed. He confirmed that all fingerprint comparisons were negative and again explains the purpose of the Ziploc bag was to preserve possible evidence. When they start processing an exhibit like the one in question, they do not have all the knowledge of the case or investigations. Therefore, the proper procedure after the DNA was lifted is to store it in a Ziploc and from there into an evidence bag. Further, that resealed means it is a new evidence exhibit bag that is used as a bag can only be used once to secure tamper-proof. Therefore, once the bag is sealed and opened, it cannot be used again. It ensures that the seal remains intact. It was placed before the witness that it is normal practice to seal the old, now damaged forensic bag into the new bag, and whether he was aware of this practice. He confirmed that indeed it is correct as per page 25 of the record. However, that yes, that is in practice, but it is not a standard operating procedure. The witness confirmed he had the spent cartridge case in his possession on the 3rd of August 2018 from 08:45 to 1600, so therefore 4 p.m. in the afternoon. With regards to paragraph 14 of the statement, the witness testified that he had not had sight of the photos of the stage or podium and relied on the investigating officer to point out the points to him. The witness confirmed that he agrees in order to produce accurate measurements, one will need to know the size of the items, stating it is why he indicated to court and cautioned the court that it is an estimation and definitely not accurate measurements. On further questions, the witness confirms that the stage shown to him depicted on the photos are indeed large in structure. He also confirms that he was not aware of the other structures as depicted on the photos. He had been shown by the defense in court, which includes the catering tents, etc. He confirms that he is able to see the white tents or structures on both sides of the stage. However, at the time of measurements, the witness had agreed to and had, from the onset of the examination, confirmed to be an inaccurate assessment or observation by the defense in that for a spent going too fast and I'm missing a full stop or a comma here. Just a minute. The observation by the defense placed to the witness is that for a spent cartridge to travel from a stage to where it is said to be found would have had to travel through several items, and the witness had confirmed that indeed that would have assisted him in drafting a more accurate assessment of the observation. It was put to the witness that the ejection range is a medium of 2.4 meters and 1.2 meters back, which the witness confirms as correct. The witness confirmed that a spent cartridge or ejection of a spent round will never travel or be 23 meters as indicated on his estimation of the measurements. The witness then explained that per record verbatim, page 32 of cross-examination, the question of the direct ejection and the travel distances traveled will have to be answered by a ballistic expert before the court. As a crime scene reconstruction expert, he would like to point out to the court that a direct ejection from the firearm to the surface it was found is not the only way that it is possible in this case. It is also possible that the cartridge case could have been picked up and then carried to that area from the firearm, or it could have just been dropped from a completely different area from where it was found. It was then placed before the witness that if he concedes anything is possible, it could have been placed there 6 months before the time. Cross-examination by Advocate Matthews on behalf of accused 2. The witness was requested to refer to photo 4 of the photo album, and it was put to the witness that it displays a very unique mark on the cartridge case, which the witness confirms and referred to as damage to the cartridge. It was further put to the witness that Exhibit A, photo 4, does not reflect or show any mark on the cartridge. The witness replied and confirmed that the section visible on the photo, the ejector mark, is not visible there. The witness also confirmed that he referred to the mark as damage or a scratch mark, even a prominent scratch mark. The witness was referred to photo 129, which depicts the firearm CN SPA 24914, and photos 128. The witness confirms that photo 128 is a photo of the complete firearm, and photo 129 is a close-up photo of the serial number already placed on record. It was placed before the witness that the firearm in question does not have a fold-up butt, to which the witness replied, it is best answered by a ballistic expert. Advocate Matthews put to the witness that it does not take a rocket scientist to establish this fact. And the witness was asked to look at photo 140 and continue to say, your training as a forensic expert, does it not include being able to identify firearms? The witness replied, identify, and it was put to him, yes, firearms. The witness explained that is a discipline on its own. However, he was told, well, just look at the photograph 140 and photograph 128 where the butt pushes in and out, and I want to put to you that the CN SPA 24914 does not have a fold-up butt. It has a butt that pushes in and out. You can expand on it and push it back in. Do you dispute that? The witness replied he had no idea. Exhibits submitted at this point, the section 212 Act 51 of CPA Act 51 of 1977, Sept as Exhibit D, key to album Exhibit D1, photos 1 to 272, image of the simulating shooting photos, Exhibit 1 to 5, marked Exhibit 3. I know there's Exhibit D4. I'll place that on record tomorrow. Sure. Okay. Let me just endorse the charges. Will we have the same arrangement between the state and the defense that the media may set up ahead of time so that there's no delay, or will there be an objection from any of the parties? I think that is so. The media, if you are willing, you are welcome to do it as early as possible for us to proceed. Just want to endorse the court book. Accused 1 and 2. I have tried by all means to read as fast as humanly possible, but the time has caught us, so the matter will continue tomorrow, and I am confident that there will be sufficient time for judgment to continue. 30 September, you are both on bail, and bail is extended, and warned to be present in court to proceed by 9 a.m. Thank you.
Is the court, please?
Oh, please, sorry. You are excused, and please stand up. The other two charges, I'll endorse in my office so I can sign up for the court. Okay, I'll just endorse the court for so long it's fine. Yeah. Thank you. I think I indicated that at this point the court will deal with the evidence of Colonel Stephen Swartboy. Okay. The word released 6 years detective unit. So the investigating officer in the matter called Muko, who assigned to investigate the shooting in during the EF Sisa Dukashe Stadium, Mdantsane. He was further informed that Colonel Mkwali, being the responsible person appointed related, and he did so and started to the interview. 28 July 2018, spent recovered cartridge. Second was assigned to obtain a up the cartridge and placed in a tamper seal bag as an exhibit in the presence of the witness. Photographs were taken and the reconstruction of where the cartridge casing was picked up was pointed out, and the scene was reconstructed then by Sergeant Punzi of the local criminal record center relating to where the cartridge casing was found. The sealed exhibit bag was then booked into the SAP 13, sealed as Mdantsane, and he stated, if he recalls correctly, it being SAP 13-688-2018. He was also informed that the viral footage was forwarded to Captain Mzuko by Captain Marley Govender from the Provincial Communications Office. On the same day, thereafter, a request was made to Captain Mzuko to forward the viral footage, which was on their official handsets, meaning their cell phones, to his official handset, that of his official handset, meaning